Yep, got it. Hopefully, there's Jeff Gertler and Borough of Madison. Yeah. And then I guess I'm the Borough of Madison and because you're coming up as Michael. Oh. Okay, perfect. Thanks, Michael. Bye.
Hello.
Hello, Joe. This is Russell. Hi.
Hey, Russell, Gary here.
Okay, great.
It says the host stopped video, so I don't know. I can't see anything.
Hey, Michael, fire us all up.
Oh, there we go. There we go.
There's one.
Looks like everybody at once.
There you
There's
go.
Russell, the first photo. There's
Good.
Dennis. My name is there, but there's Fran.
Hey, Fran.
Hi, guys.
Hi, Fran.
Hi,
Good
Gary.
evening, everyone.
Hi.
Hi.
Hey, Russ.
Hi, Dennis.
Anybody else has video can, there's Mary Sue,
Hi, everyone.
Peter, Rob,
Sue.
bit by bit.
Hi, can anybody hear me? Roger Paisel,
Oh, it's a little distorted, Roger.
Welcome back, Diane.
okay, I can't
I
get my
can see
video.
you. I don't think you can see me. Start my video. Okay. There we go. I'm here.
There he is.
One.
How about turning on Joe Santoro? May need him sooner or later.
1, 2, 3, 4. Joe makes 5.
Roger.
I don't have the Diane.
Yeah,
There we go. There we go.
I'm on.
1, 2, 3, 4,
Ah, hey.
5, 6.
Hey, how you doing, Christine?
Hi,
Hi.
hey, Russell.
Hello.
I see Russ.
Anthony.
Can- And you can hear my voice. It says I'm not muted.
It's better,
I'm here.
Roger.
There's Anthony. Great.
Okay,
Does that give us 7? We're supposed to have 1, 2, 3, 4, 5, 6,
there we go.
7. Yeah, we have all 7.
That's good.
I think we reported before that Helen Carr and James Foster are stepping down on this one. So we have a full 7 complement of members and alternates.
Okay, good.
And we've got a couple minutes to go.
Remington. Come on, lay down. Okay. Come on down.
Yes, can you hear me? This is Jeff Gertler.
I can hear you. Hey, Jeff.
Very good. Good evening, everyone.
And Michael, I assume the public is going to be able to watch but not talk at this point in the process?
Correct, Gary.
And there, I saw Rob Simon somewhere. He's here, I know. There he is. Hi,
I'm
Rob.
here. Can you hear me?
Yeah, that's fine. And if
Looks
we
like
get
Mary
the
Sue-
public comment, I'll swear them in to extend its testimony, and they'll be able to be seen at that point.
Looks like Mary Sue dropped out. We have her still.
Who's that, Joe?
I don't see Mary Sue. There she is.
Oh,
I'm
there she
still
is.
here. Just went to get a coffee.
Oh, that's okay. Just make sure you didn't fall off the Zoom or something.
It's 7:30, so I don't know if you want to give it a few for other people to join in, but
All right, we'll give it a minute or two because
the
I
full
wanna-
complement of the board is here.
okay, let's give it one more minute and we'll get started.
I think the only procedural matter we have is to formally schedule a special meeting for February 25 for the 295 Main Street application. They asked for that.
That wasn't on tonight's agenda. It's on the February 11th agenda.
Right, but we can schedule it tonight. I mean, I know they noticed for February 11 and then we can carry them, but if we, my view would be to, if we're gonna formally schedule a meeting, that's all we'd be doing tonight.
Is Mr. Wilson, is everybody from your side here on Zoom? I think he's muted.
Where'd he go? Peter, you're muted. There you go.
Yes, yes, Mr. Chairman, everybody's here on our team.
Okay, why don't we get going?
Yeah.
Everybody good with that?
Good.
Okay, this meeting, the Borough of Madison Zoning Board of Adjustment is now called to order. This is a special meeting of January 28th, 2021. Could I get an announcement of notice?
Let the minutes reflect that adequate notice of this meeting has been provided in the following manner. At the reorganization meeting of the board held on January 14th, the board adopted a special meeting schedule for this evening. A copy on January 15th, 2021, a copy of this meeting was posted at the bulletin board at the main entrance of the Hartley Dodge Memorial, was sent to the Madison Eagle and the Daily Record, and filed with the Borough Clerk, all in accordance with the Open Publics Meeting Act. In response to public safety considerations and legal authorization, the Board of Adjustment began conducting its monthly meetings remotely using the Zoom platform, and subsequently separate notices have been published each month advertising of this change and indicating that the procedures and requirements for monitoring such meetings and for making public comment, along with an explanation of the audio meeting function of the electronic communications platform being utilized, is provided with detailed information on how to use Zoom and participate, found on the RoseNet webpage, Communications Virtual Meetings.
Thank you very much. May I have a roll call?
Mr. Dianio,
Here.
Mrs. Driscoll,
She's,
you're muted.
You're
Sorry,
muted. Oh, there you go.
That's okay. Mr. Fitzsimmons,
Here.
Dr. Paetzel,
Here?
Ms. Salco,
Here.
Mr. Santoro,
here.
Ms. Teratelli.
Here.
Thank you.
Okay, would you all please join me in the Pledge of Allegiance? Fran has the flag. All right, I pledge allegiance
Allegiance
To the
to
flag
Of the United States of America,
America,
and
to the republic for which it
which
stands,
one
one
nation,
nation, under God,
God,
indivisible,
indivisible,
liberty and
liberty
justice
and justice for all.
for all.
Just for all.
I think we get a little better at every one.
I don't know why it's so harder to synchronize in Zoom versus live meetings, but it is. Anyway,
So we have no minutes for approval at this meeting. So as Mr. Hall had indicated, we should discuss scheduling a special meeting, and then we're going to get into the application for Madison Movie Development LLC. So Gary, do you want to just,
yeah, I think Fran polled everybody. This is the 295, 297 Main Street application that's been pending. Well, it's been filed for a while, but it's now complete. The attorney Steve Azzolini sent a letter in a week or two ago asking for a special meeting, agreeing to pay the special meeting fee, and Fran polled the board, and it looked like a doable date was February 25, which is a fourth Thursday in February. I think everyone was available, including the two members who have stepped down on this application. But so I guess all we need to do, if that works for everybody, to schedule a meeting. We'll deal with what goes on at the next February 11 regular meeting.
Can we get a motion to schedule that meeting on the 25th?
So moved.
So moved.
Second?
Sure.
Second.
Okay. Can we get a roll call? All in favor? Excuse me, all in favor,
Aye.
please say aye.
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 Opposed? Okay, so.
Okay, so that's done. So,
Okay.
Fran, I don't know if we need the notice for that, but you can do that. And but the official adjournment carrying the application, that'll be done in the February 11 meeting.
Okay.
All we need now is just to formalize that the board did schedule a special meeting. Okay.
And the fee.
And the rest of the night is for Mr. Wolfson and his client. They've we scheduled this at their request. They paid the fee, and he's the applicant's attorney, and we do acknowledge Mr. Simon representing some public members. We did get a member client list earlier this evening, an email this afternoon, I should say. So, and I know Mr. Simon has some procedural items he'd like to present. So maybe we should do that, Peter. I defer to you before you say anything. You can enter your appearance, obviously. I suggest that, and then we go from there.
Thank you, Gary. Peter Wolfson of Dave Pitney. Also with me tonight is my colleague, Luc Pontier, who has been intimately involved in this application and the applications on this project that preceded it.
And Peter, I understand you spoke to Mr. Simon. You know who he is, and he had asked to be given the opportunity to present some procedural objections or issues up front, so we can all consider them as we go forward.
I did, and that's my understanding as to how the board's going to proceed.
Okay, Mr. Simon, the floor is yours, I guess.
Thank you, Mr. Hall, Mr. Wolfson, members of the board. Good evening. My name is Rob Simon. It's good to be back here before the Board of Adjustment. I am here on behalf of my client, Save Madison Theater, Inc. I'm an attorney with Herald Law in Warren, New Jersey. Before actually I even get started with regard to what I was planning to discuss regarding jurisdiction, notice, application issues, I do want to bring a matter to the board's attention that I literally just found out about a minute ago. I do see that Ms. Driscoll is I believe, a member of the Board of Adjustment. I want to disclose that I represented years ago a group of which she was a part. I don't believe that serves as a conflict, but I want to disclose that to the board in fairness. I probably would like to hear from Mr. Wolfson with regard to that, and Mr. Hall as well.
Yeah, that's fine. That was a prior representation. I'd forgotten all about it until I spoke to the administrator the other day, and he reminded me about Mr. Simon's role. And for the benefit of everyone else, this was proceedings concerning the lighting of the Cougar Field, which is in Chatham Township, except the end zone is in Madison, and Diane lives nearby. And there was a neighbor group that objected to what Chatham Board of Ed wanted to do, and Mr. Simon represented that group. That was, I don't know, I lose track, maybe 10 years ago, 8 years ago. It's been a while.
2007, 2008.
Oh, more than 10 years. Okay.
So
I don't
it's
view
almost
it as a
ancient
conflict,
history.
Diane. If you feel it would impair your integrity or ability to be objective, you can step aside, but.
No, I do not feel any
Okay.
such consideration.
Mr. Wilson, do you have any concerns?
No, we accept that. Thank you.
Okay. Mr. Simon, I think that's good, but
Right,
thank
no,
you.
I think
for
that's
that one.
fine. I just, I would have been remiss if I didn't
Yeah.
at least bring that to the board's attention. So thank you for that.
That's fine.
So I have already, and I guess the other bit of housekeeping before I start, Mr. Chairman, would you like me, for the benefit of the record, to identify the members of the Board of Trustees of my client, Save Madison Theater, Inc.
Well, maybe you should, just so that the public that's listening understands who that is.
Sure,
Yeah, we
thank,
saw a list, but nobody else did, I suspect. So why don't you just quickly put that on the record?
absolutely, Gary, no problem. So the Board of Trustees of Save Madison Theater, Inc. Are comprised of the following. Sandy Kulikowski, President, 136 Park Avenue, Madison. Robert Pratt, Vice President, 25 Sherwood Avenue, Madison. David Hanna, Secretary, 87 Central Avenue, Madison. Michael Mernon, Treasurer, 63 Montclair Avenue, Montclair. Elwood Kurseslager, I believe that that's correct, 60 Prospect Street, Madison. Andrew Breckman, 22 Green Hill Road, Madison. Catherine Coultis, 10 Stonehenge Lane, Madison. Joseph Falco, 51 Delwood Drive, Madison. Deborah Fennelly, 88 Constitutional Way, Morristown. And James Gilbert, 48 DeHart Street in Morristown. So that is comprised the Board of Trustees. And I have instructed the client, as is appropriate, that for purposes of participating in this development application, that those who I have just listed are precluded from asking questions of various witnesses by way of cross-examination. So with that, let me proceed in terms of some procedural issues that are important, that we believe are important. The first constitutes notice, and as you all know, one of the fundamental requirements of the municipal land use law is that the public must be fairly apprised of the application and the relating hearing. So to consider the application, and that's set forth in section 11 of the municipal land use law, and the purpose of that law and its progeny, including the seminal case of Perlmart v. Lacey, which is an appellate division case from 1996, I believe, is to make sure that members of the general public who may be affected by the nature or character of the proposed development are fairly apprised of the application so they can make an informed decision and determination as to whether they should participate in the hearing with sufficient time, or at least look more closely at the plans or other documents that are on file. And I emphasize that there be sufficient time for that, and the required public notice provides that the public is allowed at least 10 days prior to the scheduled hearing to review or to be noticed of the application. And that notice is required to contain various elements, including, of course, the date, time, and place of the hearing and the nature of the matters considered, and an accurate identification of the property proposed for development. And it says by street under the municipal land use law, section 11, it says by street address, if any, or I believe by reference to lot and block numbers, etc. So, and as you know, the board needs to make sure that it has proper notice of an application so that there's proper jurisdiction for the case so that it can proceed. Now I've taken a look at this, and we do believe that the notice is deficient for a number of reasons, as well as the application being deficient. And I'm going to rattle off some instances as to why we believe that it is deficient. First of all, the public notice that I reviewed that was published, and I believe it was published, and I believe it was published on January 14th. It does not mention any street address of lots 11, lots 22, lots 23. It doesn't even mention both the lot and block of lots 11, 22, and 23. It does not mention the existing or proposed uses of lots 11, 22, and 23. I will tell you that also a quick look at the application made me realize that there's a lot that's missing from this application, and that's namely lot 12. And the reason why lot 12 is missing from this application is that it is an undersized lot in common ownership with lot 11. which is part of this application, which I'll get to in a second. So the fact that lot 12 is not part of this application, is merged with lot 11, and it's merged not only because it's undersized, but also because it has a common owner, which I believe is Madison Main Associates LLC. And I believe when I looked at the notice that was submitted by the applicant and their request for a property owners list, they did not include lot 12, which should be part of this application, as merged with lot 11 for the reasons I just stated. In addition to which, so besides the deficient notice for lot 12, that the application doesn't even mention lot 12, the notice, neither the notice nor the application mentions that the uses of lots 11 and 12 are currently prohibited in the subject zone, which is the CBD 1 zone, and which is ironic in that in the, I guess, proposed easement agreement that is part of the application, if you read carefully, that it is contemplated in that agreement that lots 11 and lot 12 are both subject to that agreement. So that is clearly evidence of the fact that lot 12 merged, it's under common ownership. It should have been they should have had notice within 200 feet of lot 12. They failed to do it. They failed to include lot 12 as part of the application. In addition to which, as you know from your review, ladies and gentlemen, of the application, it's pretty clear that there's use by lot 24, which is the lot that is the subject of the application, of an adjoining lot, namely lot 23, for ingress and egress. And based on your, and that's an accessory use, except that in Madison, as we know, that to comprise an accessory use, I believe under your definition, it doesn't only have to be customarily incidental and subordinate to the principal use of the lot, but it also has to be located on the same lot as the principal use. And because it's not on the same lot, or entirely on the same lot as lot 24, it requires a use variance, which was not noticed for, wasn't mentioned in the application whatsoever. The notice also doesn't mention that the property is located within the Madison Civic Commercial Historic District. The notice in the application both fail to mention that site plan approval is also required for the proposed improvements that are on lots 22 and 23, which of course have nothing to do with the development of lot 24. There is a mention of lots 22 and 23 in the notice. Not only does it not mention the block that they're located in, but all it says is improvements on lots 22 and 23. Clearly pursuant to the Madison ordinance, the nature of the improvements that are being proposed on lots 22 and 23 trigger the need for a form of site plan approval, which hasn't been noticed for, it hasn't been applied for. And again, there's no mention in the notice of the nature of the proposed improvements on lots 22 and 23 in any detail, including parking lot reconstruction, striping, the grading. There's an access gate that's being proposed for the first time. So again, not only was there no site plan application ever filed for lots 22 and 23, but in addition to which, the applicant here, Madison Movie Development LLC, can't even, at least as far as I'm aware so far, be the quote unquote developer of those lots, as the term developer is defined under section 4 of the municipal land use law, because they're neither the legal nor beneficial owner of those properties, nor to my knowledge have any type of enforceable proprietary interest in those lands for development beyond the 12-foot easement strip that's located on lot 23. The notice and the application, either of them reference that lot 22 and 23 have any type of shared parking across both lots in separate ownership, as is apparent from the site plan or how that came about. In addition to which, on top of all of that, the notice actually states that the documents for this application that were filed by the applicant are available on the website of the Borough of Madison. Well, they were not all available. And I have brought that to Mr. Wolfson's attention. Of course, he's kind enough to provide me when I did bring it to his attention, as well as Mr. Pontier, with the documents, but that was 2 days prior to the hearing. Of course, certainly not 10 days prior. And so the certain documents, certainly whether it was I think the Stormwater Management report, the planning report, the traffic report, were not available on the website at least 10 days prior to this hearing, which is ironic because actually when you go to the website, it says documents will be available for public viewing at least 10 days prior to the hearing, but that wasn't certainly the case. In addition to which, because the application notice that was published and served did not include the application number, there was no way for the public, including myself, who I profess to be a seasoned land use attorney and also a board attorney in a number of communities. I had no idea when I went on the website how to find the documents.
And that's why you called the secretary, as the notice
I
said.
was just about to tell you that, of course. And I called up Fran. I explained I couldn't find them. She explained to me that what you needed to do was to go find the application number and then click on the application number. And so that is what I did. But at the same time, I will tell you, and I explained this to Mr. Hall in a prior conversation that he and I had yesterday, I believe, that it is not easy. It's not what is required, certainly under the new administrative code provision 5:39-1.7 that requires clear instruction in the notice on accessing the application materials. I'm not blaming anyone, certainly on the Madison side. I'm just being very truthful in terms of the difficulty to even access, the documents and the files. And of course, I explained that Mr. Wolfson was kind enough immediately to forward to me everything that I asked of him, certainly. The other thing I want to point out to you in terms of the application itself is that if you look through the application, that there are certain landowner consents. And there's a landowner consent for lot 11, lot 22, lot 23. If you look carefully, the landowner consent for lot 11 was dated December 21st, 2018. The landowner consent for lot 23 was dated December 11th, 2018. At the time, this application did not exist. And in fact, at the time, it was a different application, from what I understand, before the planning board, not the Board of Adjustment. So certainly we consider that under the municipal land use law to be a defect or deficiency, because clearly the owner of lots 11 and 23, based on that landowner's consent, could not have reviewed the application and the accompanying plans and provided consent because the application had not even been in existence, certainly at the time. So, and the only other thing I want to add at this time, and I appreciate your indulgence in allowing me to speak at the commencement of this hearing with regard to these, what we believe to be very important jurisdictional issues, is also I join on behalf of my client in the objection that was expressed, I believe, by the Environmental Commission in terms of permitting this application to proceed while waiving the need for the applicant to provide an environmental impact assessment. And I just want to add that under the applicable provision in your ordinance that requires basically, if the board, it says the board may require the applicant to submit environmental impact assessment as part of preliminary approval. And those considerations do not just deal with issues surrounding, water quality and hydrology and geology and soils. They also include issues such as land use, aesthetics, and historical issues. So for that reason, we also join in the request or our position that an environmental impact assessment should be included by the applicant as part of this application. So I'm gonna stop right now, and thank you.
It's a guess we hear from Mr. Wolfson.
Thank you, Mr. Hall. Is that it, Mr. Simon?
I'm sure I have more, Peter, but let's go from there.
No, put them all out. I'm trying to take notes.
Yeah,
Do you have other procedural preliminary issues?
no, those are the only ones I've come up with so far.
Okay. We reject all of Mr. Simon's criticisms, and we wish to go forward with the hearing based upon the adequacy of the notice and the other issues that he raised. First of all, rather disingenuously, his characterization of our notice in the notice itself, which is 3 full pages, there is a specific information. The application, I'm quoting, documents, maps and plans for which approval is being sought are available for public inspection on the Borough of Madison website at the following web address, www.rosenet.org. What Mr. Simon was referring to as, quote, missing were not the application materials that the law requires. They were submitted well in advance of 10 days. In fact, they were submitted much further out from this hearing than 10 days. The materials he refers to were some review memos that have been generated, and there's been a whole slew of them, many of them received as recently as yesterday. There's no requirement that those materials be up any sooner than 2 days before, pursuant to the guidelines that have been promulgated for these types of virtual meetings. So that is our response on that issue. In terms of not knowing how to go about gaining access to the materials otherwise, the notice says, individuals lacking the resources and know-how for technological access to the application plans and other documents or access to the virtual meeting should contact the Board Administrative Secretary, Francis Boardman, by telephone at 973-593-3060 or by email at boardmanf@rosenet.org. Lots 11 and 12 are shown as separate lots and are carried as separate lots and are not shown as merged on the municipal records. So we reject the criticism that lot 12 required any further treatment. The consents that we obtained from the 3 adjacent neighbors are valid, and I can represent to the board that I've been in contact with the attorneys for all 3 of those neighbors to discuss certain review comments that were made by the board professionals, and that they're fully aware of this, and that the consents in fact referenced the zoning board application, and they have received the materials in each case and reviewed them and approved them. In terms of Mr. Simon's comment on the environmental impact statement, we have requested a waiver. The board can determine whether a waiver is acceptable, and it is not uncommon when a board starting a hearing determines a waiver is acceptable, that's the end of it. But if they determine that they want to see it, there is well-settled law that the board can ask to see it going forward. I think those are the issues that I jotted down as he rattled off his objections. There's no obligation legally or otherwise to reference the historic district. There are references specifically to the parking area on lots 22 and 23, which are shown on the plans. There was a criticism that we don't describe what we're doing. We do, it's in the notice. I think I've covered everything. And with that, we would respectfully request that we proceed with the hearing.
Just a couple of responses, and I'm going to just remind Peter, because I like him very much in all sincerity. He has not yet addressed the issue about needing to file a site plan application for lots 22 and 23. I will additionally state, with regard to the comment about the documents being on file. If you notice, when I spoke earlier, I didn't say a peep about professional reports from the board. What I said was that the documents that are required to be submitted for this application, for it to be deemed complete, including the applicant's traffic report, including the applicant's planning report, including the applicant's stormwater management report, were not available on the borough website 10 days prior to this hearing. Whether or not the applicant's notice was 2 pages, 3 pages, or 20 pages, it does not comply, the reasons stated, with the requirements of the Promark case, Section 11 of the Municipal Land Use Law, and the application, we respectfully contend, is deficient. And the reason why in every application I've ever done, and Peter would hopefully remember the ones he and I have had in the past, will always bring these issues up at the commencement of the hearing or the proceedings to give the applicant a full and fair opportunity to correct the deficiencies. That is why I'm raising them now, as opposed to sitting on my hands and doing nothing until the time comes for the surrounding property owners or other interested parties to present a case. So I'm doing it as a courtesy, but also as a courtesy to the board, so the board is well aware from the get-go of our position, at least in terms of jurisdiction, with regard to this application. Thank you.
If I may, Mr. Chairman, the Promark case, which Mr. Simon refers to, the standard in that case is whether it gives adequate notice to a layperson in the public of what is proposed. If you are to go through this extensive notice, we're very comfortable with the fact that it does. I will not read the entire 3 pages in there. I assume that some or all of you have had a chance to review it. In any event, let me just read a little bit of it.
I don't think that's necessary, to be
Okay.
honest. I think the board would like to hear some testimony tonight. It's 8 o'clock.
Okay.
I concur with Mr. Wilson. I mean, if you really feel compelled to,
No,
it's
I
not going
don't
to
feel
change anything.
I don't feel compelled to read the notice. Thank you, Gary, for stopping me.
Yeah,
do-
I mean, I understand, and I understand notice is an issue, but first of all, a couple quick comments. I do agree with Mr. Wilson. I think the notice gives adequate information to the public to know what's happening tonight. And frankly, I think even without the notice, people know what's happening tonight. And of course, Mr. Simon's here. It didn't prevent him from showing up. But a couple of things real quick. First, as I look at the plan, the 200-foot list is the radius map on the plans appears to include lot 12. Secondly, there's a single site plan application for all the property. There's very little being done on the abutting properties. They're repaving a parking lot. They're redoing I think a shared driveway as partly off the subject property, but they're all covered by the application. And finally, real quick, because I don't want to drag things out, and I was looking for it, I couldn't find it, but the checklist concerning the environmental impact assessment, or maybe it's a statute, it applies to subdivisions, not site plans. So if we're going to go down the weeds and read fine details, I think that doesn't even apply. But regardless, if we're here tonight, any issues of completeness have been waived by the fact that we're here tonight. And having, that doesn't mean that the board going forward, if issues come up about the environment, about anything else, you're not precluding from requiring any information you feel is necessary to make a reasonable decision. So completeness, yeah, I mean, I don't see that as an issue anymore. I don't see notice as an issue. And hopefully the board well, if you agree, we'll proceed.
Can I just add something? I don't know if this is relevant or not. I'm certainly not a land use attorney, but while I've steered clear of any news, I don't even subscribe to the Madison Eagle. I understand that this has been the subject of quite a bit of writing in the newspaper and probably forums and things like that. So I think that the issues and this application project is pretty well known across town. It'd be hard not to know about it. If that means anything, I just put it out there.
So I guess, Mr. Simon, I don't know if you want to say anything more, but I think,
Yeah, I guess the only thing I'm gonna add is, and of course, it's up to the board, but I would respectfully ask if that's what your ruling is and that the applicant's gonna proceed. And I mentioned this to Peter by phone as well. I would respectfully ask that I be given an opportunity after tonight to comprehensively review the traffic report, the planning report, and the stormwater management report before being put in a position to ask questions with regard to those particular reports of the applicant, as they were not made available at least 10 days prior.
well, Mr. Simon, the fact that you showed up on the scene 2 days ago is your issue and your client's issue, not the board's. But having said that, I'll defer to Peter as to how he wants to proceed. I know the board wants to proceed, and let's see where we get.
So my only response would be that the reports that Mr. Simon's referring to are not necessary elements of the application and can be posted 2 days in advance, which they were. Additionally, I provided them directly to him, so he had an opportunity to review them. If the board considers that they are required for 10 days, then the applicant is asking for a waiver on those requirements, despite the fact that we have submitted them. So, when you have these hyper-technical objections that are designed to prevent getting to the substance of the application on a project that has been through procedural twists and turns for 2.5 years, I am constrained to respond technically. So with that, I have nothing else to say. I would appreciate the opportunity to go forward.
And the last thing I'll say is I've advised the board, but I think it's the board's decision, not mine, as to how you want to proceed. I just want to make that clear. So, Mr. Chairman, I defer to you and the rest of the board as to what your
Well,
decision is.
before I ask the board, can I just ask Mr. Simon a question?
Sure.
Just, you can talk about courtesy to the board. Well, I don't know much at all about the organization that you're representing. I haven't involved myself at all. Don't know what they're doing. And in the interest of trying to accommodate you better, why don't you tell the board what your organization wants, what its end game is, what it'd like to do? What's it looking for? I don't understand, because it seems like you're coming up with a lot of very, very technical things. I'm just wondering whether, what you guys are seeking.
Well, it's not a question, Mr. Santoro, of what someone is seeking. When there's an application, I didn't file the application. Mr. Wolfson's client filed the application. I didn't ask for a use variance, 10 bulk variances, RSIS waivers, other waivers. The applicant did. And certainly, like what I represent clients across this state, their goals may change depending on what the testimony is, what the information is. I do take offense, by the way, at the reference by Mr. Wolfson of hyper-technical objections. They are objections that are incredibly appropriate under.
I disagree. I agree with Mr. Wolfson. I have to jump in, and they're hyper-technical.
Well, the reason,
I agree.
let me just say, the reason that I say this, and this is, I'm trying to be as open and honest and fair with you, Mr. Simon, as possible, is you just came in, whatever, today, yesterday, you don't have the background. And there's a lot of things that have already been decided. So the demolition has already been decided. The applicant has the right to demolish the building. The matter of trying to mandate or make or require the applicant to have a theater use in there, that has already been decided. So when I ask, what do your clients want? If they, with the name Save the Theater, I mean, that's already decided. So I'm just curious as to where this is going. And, maybe we could help you get there, satisfy that in good faith.
I appreciate the question, Mr. Chairman. I think that I can't answer the question other than to say that we have concerns about the application in a number of respects with regard to a lot of things, including all the violations of the ordinance and the residential site improvement standards. If the applicant presented a fully conforming application, I typically do not get involved in them. And the applicant is free to apply for a fully conforming application for whatever they want. But since they haven't, my client has retained me, and we intend to ask questions and participate with regard to this application.
That's very responsive answer. It tells us nothing, frankly. And by the way, you're entitled to ask for a variance, and that's what they're doing. And that's what the Board of Adjustment is here for. to
Well,
consider it. They don't have to approve it, but that's what they do.
Well, I'll just throw this out there. My concern is when we heard the appeal related to the theater, my sense is that there were a lot of people who didn't understand what was going on. And I'm just concerned that, hey, maybe the people that you're representing don't fully understand what the status of this is. And I'm just encouraging you to make sure that they understand that. I wouldn't want to spend a lot of money and go through this process when trying to change things that have already been decided. That's all I'm saying.
No, the comments are appreciated, and I can assure you that I'm providing what I believe is good legal advice to my client.
Okay, well, I would like the board to weigh in. I believe that we should proceed tonight. I doubt we're going to get through the whole thing, so I think Mr. Simon's going to have plenty of time to review all these materials and ask questions later. I'm not going to say you can't ask questions about something next month or whenever we continue, but I think we should move ahead. So how does the board feel?
Joe, I agree with you. I think we should proceed. I think if what Mr. Simon's client's wish is to comment on the variances requested, that's exactly what we're here for tonight, is for comments and input on the variances. I mean, this is what we do. People come in and they ask for variances. We wouldn't be here if they weren't asking for variances. So go for it.
Mr. Simmons, what do you think?
Agreed.
Everybody else? Good?
Yeah.
Yes.
Not anybody? Okay, all in favor of proceeding tonight, please say aye.
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 Opposed? Okay, we'll proceed.
Thank you. Appreciate that. Again, Peter Wolfson of Day Pitney here on behalf of the applicant with my colleague Luc Pontier. We've already talked about what the property is, where it's located. We submitted this application to the zoning board for preliminary and final site plan and variance relief on September 4, 2020. We then submitted a revised application on November 30, 2020, to address comments we had received from your professionals. The applicant is proposing a development that will provide a much-needed resource for Madison's downtown. In many aspects, the development conforms to what is permitted on this property. The zoning ordinance contemplates a mixed use of retail and residential, both of which are proposed as part of this project. Importantly, the building complies with the 45-foot height requirement. Although Mr. Stern has opined that the building may be interpreted to include a fourth story, our architect, Jeff Gertler, will provide an explanation of why we believe the building is a compliant 3-story building. The project also meets the prevailing front yard setback requirement for the district and improves upon the existing impervious coverage and rear yard setbacks. The applicant has demonstrated consistent willingness to work with the borough, its professionals and residents, its agencies, to create a project that will invigorate the downtown district and fit in with its surroundings. The proposed building, while incorporating modern conveniences, honors its place in the historic district. This is a transit-oriented development directly adjacent to train and bus service. Additionally, significant permitted public parking is available within easy walking distance from the site. It will provide much needed retail to the downtown district, and it will provide 24 residences of brand new upscale living units, bringing in residents to shop, eat, live, and work in Madison. The property currently contains one commercial building previously used as a movie theater, which will be demolished. The applicant received a certificate of historic review from the Madison Historic Preservation Commission by resolution number 3-2019 to demolish the building. That was dated July 9, 2020. As this board is aware, the applicant thereafter successfully appealed certain HPC conditions to this board. Additionally, the applicant satisfied any remaining conditions placed on the certificate of historic review for the demolition, as evidenced by correspondence from the Historic Preservation Commission dated September 18, 2020, that correspondence being directed to your board. The applicant seeks preliminary and final site plan approval to construct a multifamily residential building with ground floor retail and below grade parking containing a total of 24 residential units, together with associated common and amenity space, approximately 1,788 square feet of retail space, and related site improvements. The applicant also proposes certain improvements on lots 11, 22, and 23, as shown on the submitted plans. This project will provide the borough with 4 units of restricted affordable housing. Of the 24 residential units proposed, there will be 8 one-bedroom, 15 two-bedroom, and 1 3-bedroom unit. 6 of the residential units are proposed for the first floor of the building located behind the retail space. And that gives rise to the use variance that we seek from you to permit ground floor apartments, where apartments are currently permitted only over stores or offices. It is interesting to note that first floor residential is permitted in other commercial zones in Madison. In connection with this project, the applicant proposes a total of 11 building signs with a total area of approximately 78.9 square feet, including 3 signs each for retail space, 4 building identification plaques, and 1 sign for the residential use. The applicant also proposes conforming directional signage on the property. In the application submission, we noted that 10 signs, including 3 building identification signs, were proposed for a total sign area of 73 square feet. You'll note that I just indicated that we now seek 78.9 square feet. Following meetings with the HPC, the applicant added a plaque to include additional historic information over that originally proposed, increasing the number of building identification signs by 1, and thus the total area as I detailed. For the record, I'd just like to note that we have received the following review letters from board professionals and other borough agencies. Borough Engineers Review dated October 6, 2020, last updated January 26, 2021. Board Planners Completeness Review number 1 dated October 12, 2020. Board Planners Completeness Review number 2 dated December 6, 2020. Board's Traffic Consultant Hamill Associates Review Memo dated November 4, 2020. Board's Traffic Consultant Hamill Associates Review Memo number 2 dated January 26, 2021, and that acknowledged receipt of our response that we had written to Mr. Hamill's report. Board Planner's Substantive Review Memorandum dated December 31, 2020. Board Planner's Substantive Review Memorandum number 2 dated January 24, 2021, acknowledging receipt of our detailed response to his first memorandum. Environmental Commission Review Memorandum dated January 6, 2021. Environmental Commission Review Memorandum number 2 dated January 11, 2021. Environmental Commission response letter to our letter responding to their initial letter, that third letter from the Environmental Commission dated January 28, 2021. Historic Preservation Commission Review Memorandum dated January 26, 2021, and Sign and Facade Committee Review Memorandum dated January 26, 2021. The applicant submitted a memorandum dated November 30, 2020 to address the Board Planner's Completeness Review number 1 and Hamill Associates Traffic Review. The applicant also submitted point-by-point detailed responses to the planner's substantive review and the Madison Environmental Commission review. Our responses were each dated January 15, 2021. Each of those letters was addressed to the board, and we trust they were distributed to the board members. We ask that all these reference materials be included as part of the record. In addition to these letters and memorandum,
Hey, Mr. Wilson,
yes, sir.
there was also, I don't think you mentioned it, but there was a Downtown Development Commission memo of Jan 26. Did you get that one? Do you have that? Gary, that's the one that rolled in on yesterday or the day
Yeah, it
before?
wasn't posted yet, so I don't know that anybody's seen it
I
except you
may
and me.
have, let me just check through my very thick pile here.
That's one that's signed by Suzanne Whitehorn and Eric Range. I want to make sure that that finds its way into the process here.
Yeah, that could be posted later. We're not going to finish tonight, as I think you acknowledge, so.
Okay, I just want to make sure that that one is noted.
And
Yeah.
we'll hear testimony presumably from someone from DDC about that.
Okay, thank you.
Yes, thank you, Mr. Chairman. We have not seen that memo, so we look forward to getting a copy of it. In addition to these reference materials, the applicant met with the fire chief with the applicant's professionals on October 16, 2020, and satisfied any concerns that the fire department had with this application. Just by way of further housekeeping, and I appreciate the indulgence, outside agency approvals pending are before the Morris County Soil Conservation District and the Morris County Planning Board. With that, I'd like to just indicate that I have with me tonight 3 witnesses: Eric Keller, who is our project engineer and traffic engineer; Jeffrey Gertler, who is our project engineer, or project architect, excuse me; and Paul Phillips, who is our project planner. I'd like to start with Eric Keller to provide civil engineering testimony, if I can call Eric at this time.
Please do. Yes.
I'm sorry, Mr. Keller, will you raise your right hand, please? You
Yes, sir.
solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You're sworn.
Thank you.
Good evening, Eric. Can you just give us your affiliation? I see it in proud green behind you.
Thanks, Peter. Yes, Eric Keller, Bowman Consulting, 54 Horse Hill Road, Cedar Knolls, New Jersey.
Can you also share with us a brief background on your professional and licensure and educational experience in both the areas of traffic and civil engineering?
Certainly. I have a Bachelor of Science degree from Rensselaer Polytechnic Institute in civil engineering. I attended a master's program at the University of Maryland. I've been a licensed professional engineer and planner in the state of New Jersey since 1987. I have appeared in Madison, though it's been some time. My firm in the past was the consulting engineers for the borough, but has not been for a number of years. I have also appeared before numerous boards throughout Morris County, both providing civil engineering and traffic engineering testimony on similar projects of similar size and character as the application before you this evening.
Okay, we're going to accept him as an expert.
Thank you, Mr. Chairman.
Eric, start. Go ahead.
Mr. Chairman, I'm sorry. I apologize for interrupting. Can I just ask Mr. Keller just 2 quick questions?
Sure.
Thank you, Mr. Chairman. Eric, good evening.
Good evening, Rob.
This evening, you're just providing engineering and not planning testimony, correct?
Correct. I am not testifying as a planner this evening. That is Mr. Phillips.
And do you recall, Eric, the last time your firm provided consulting engineering services for Madison?
For the boards, it has been probably 5 years. We stopped being the board engineers when Mr. Russo joined Madison as the assistant borough engineer. And he left my firm, so it has been several years.
So other than that board work, Eric, you or your firm has not provided any engineering services for Madison, correct?
No.
Nothing further. Thank you, Mr. Chairman.
Thank you.
Thank you, Mr. Chairman. Eric, can you provide first a description of the existing conditions and orient us to the location and the site? And then go on from there to describe the proposed project from an engineering perspective.
Yeah, before you do that, do you want to identify the plan so we can make sure we all have the same thing?
Sure. The plans are dated September 4, 2020 and last revised November 18, 2020. Is that correct, Eric?
Yes, it is.
And there are 9 sheets.
Are you going to share screen on this?
Yes, I was going to, Mr.
Okay,
Chairman.
that'd be a little easier, maybe.
I just want to make sure we all have the same plans. They are
Right.
posted, I know. I mean,
I'm going to start. I've put up sheet 3 of the site plans. And these are the plans that Peter just referenced. So in the kind of the center portion of the site is lot 24 with frontage along Lincoln Place, containing an existing building, a paved area along the post office, which is to the west. Just for directional purposes, I'm going to consider Lincoln Place east-west, and north would be to the right of this sheet.
Hey, could you maybe do a screen view or something, blow that up a bit, because it's sort of should be bigger, I think.
Okay, I just wanted to show the overall plan because I want to give a
Okay.
context of this, and then I will zoom in if that's okay, Mr.
Yeah,
Chair.
I think you just screen is the one small side, but whatever.
Okay. The property is located at 14 Lincoln Place, identified as block 2702, lot 24 on the borough tax map, and the property is located in the CBD 1 zone. So zooming in to the property itself, as you can see, the site has 82 feet of frontage along Lincoln Place. The lot varies in depth between 130 and 149 feet. There's a little notch in the northwest corner of the property. The site is is almost fully occupied by the building. The building coverage today is almost 81%. The impervious coverage is 98%. The only portion of the site that is not paved or contained by a building is a small area in the far northwest corner of the property. The property slopes from Lincoln Place to the rear. There is about 12 feet of fall from Lincoln Place to the rear of the property. The adjacent areas there is, just slide this up a little bit. Lot 23 is the lot to the east of us. There is an existing paved driveway that is approximately 15 feet in width that extends between the existing building on lot 24 and the building on lot 23. That driveway today is wholly contained on lot 23 because the building on lot 24 extends to the property line on the front, the side, and the rear. It is, other than the west side, it is, extends fully to the lots, to the lot perimeter. The building height is measured under the borough code is 47.5 feet today. The required parking for the theater, which contained 435 parking spaces under the borough code, was 145 parking spaces. There is no existing parking on the subject property today. The surrounding parcels, as I said, the post office is to the west. The Madison train station is to the south across Lincoln Place. There are commercial buildings to the east on lot 23 and lot 22, and further to the east along Lincoln Place. To the rear on lot 11 is a residential structure. And on lot 12, there's also it appears to be a residential structure. In the more general area, this is a block off of Main Street, as everyone is aware, which this area is in a downtown, which contains a mix of commercial and residential uses, as well as the Borough Hall, which is across on the other side of the train tracks. The existing, I mentioned the existing driveway between the two buildings is 15 feet in width. There is an existing 12-foot wide right-of-way recorded across lot 23. There is this existing driveway is approximately at a slope of 10%, and that will come up later when I start talking about design waivers from the borough code. Now, I want to go to sheet 4 of our site plan set, which is entitled Layout, Grading, and Utility Plan. This shows the proposed building, the proposed driveway improvements, and as well as the proposed parking lot improvements on lots 22 and 23. This application will result in the demolition of the existing building on lot 24 and the construction of a new 3-story mixed-use building with retail and residential uses within it. Mr. Gertler will get into the details of the building. I'm going to stay on the outside and talk about the site improvements. So anything related to the interior of the building should be directed to Mr. Gertler. This proposed building will meet the building height requirement in the CBD 1 zone of 45 feet. And it also meets the predominant front yard setback, which is the standard for this zone. This building will contain 24 residential units, and I'll let Mr. Gertler again get into the details of those and the number of bedrooms and so on. And it also contains 1,788 square feet of retail space, which is on the, call it the first floor of the Lincoln Place level, fronting on Lincoln Place. To zoom in a little bit so you can see this better, I'm going to focus on the driveway between this proposed building and the building on lot 23. This driveway is being widened. It's being widened to the west onto the subject property. Currently, as I said, it's about 15 feet wide, and it will be widened to a uniform width of 20 feet, which is an increase of 5 feet over what exists today. We're also proposing a sidewalk along the east side of the driveway. And there is one point where that sidewalk is less than 4 feet wide, and that's because there's an existing step that comes out of a doorway on the west side of the building on lot 23. So at that location, that's an existing door, an existing step. So we're just accommodating it within the sidewalk. And I'll talk about that a little bit more later. We are also reconstructing the driveway apron in accordance with borough standards. We're removing the pavers from that apron and putting in a conforming standard 6-inch thick concrete apron that will extend from the curb line to the property line, and then the remainder of it will be asphalt. We will also remove and replace existing pavers along the front of the building as necessary related to any utility or building improvements that cause damage to those. To the extent that any are damaged and cannot be reused, they will be replaced. And we will replace them with the pavers that meet borough standards. The retail space will be accessed from the front facade, and the residential use is accessed along a sidewalk on the west side of the building. And Mr. Gertler, again, will get into the interior details of that, but the residential entrance is set back off the road, where the retail access is right up on the street, which is in keeping with a downtown design, and having an active streetscape along Lincoln Place. There will be a lower level, which contains 24 parking spaces. One parking space will be provided for each unit. The access to the garage is at the northeast corner of the building.
I think you mean the southeast.
Nope, northeast.
Oh, I'm sorry. Yeah, go ahead.
North is to the right.
Yeah, no, you're right.
So, and that's basically at the bottom of the shared driveway between the two buildings. We are also making improvements to the existing gravel, broken asphalt parking lot behind the buildings on lots 22 and 23. Right now, this entire area from the rear of the buildings to the perimeter of lot 12 is impervious surface, and we're going to be cutting that area back. And this area where we're removing the asphalt and packed gravel will be, those materials will be removed. It'll be topsoiled and create a lawn. And we've also agreed that we will provide some shrubs in that area and also a shade tree. And that parking area will continue to provide parking for the existing buildings on those two lots. The access into the garage is an 18-foot wide doorway, garage door, and then it enters into the building. Bear with me, I have to get to the right sheet. Sorry, my computer's being a little slow tonight. This is, I'll get to this later. This is a turning movement. Oh, here we go. This is on sheet 7 of 9, which is entitled Parking Layout and Vehicle Turning Plans. In the lower left corner of that is the internal parking layout for the building. As you can see, there's an 18-foot wide driveway here. We have looked at turning movements into and out of this garage, and there is more than adequate maneuverability for those vehicles. It is a fairly small garage. I think the likelihood of a entering and exiting vehicle passing at the garage door at any given time is very small. And even if it does occur, there is sufficient room to accommodate those movements. There's also very good sight distance of somebody coming down. They would see that the garage door was opening, which would indicate a vehicle leaving. Back to sheet 4. So as I've indicated, lot 23 is to the east of this. Lot 11 is to the rear of this. Both of those lots utilize the access driveway that comes down between these two buildings and is split between lot 24 and lot 23 and then goes into lot 11. And then the parking area for lot 22, which is in north, in the eastern portion, that is a common parking area between those two parcels of 22 and 23. In this area, we are requesting a design waiver for driveway setback. The Borough Code requires a minimum rear and side yard setback of 5 feet. Since these driveways cross the property line, they are shared driveways for each of those properties. By that specific nature, they must cross the property line. So we are seeking a design waiver for a 0-foot setback, which is, necessary for a shared driveway. And this condition exists today, and we're improving it by widening the common driveway that comes down between the buildings. As far as maintenance and snow removal of that common driveway between lot 24 and lot 23, that is the responsibility of this applicant. He will maintain it, repair it, get the snow off of it. Obviously, there's a strong impetus for that because we have 24 residents who are going to be looking to get into the garage. So, but that is the applicant's responsibility. We are also requesting design waivers for driveway grade and width. The Borough Code requires a minimum driveway width of 30 feet. We are providing 20 feet. If the residential site improvement standards were applicable to this driveway, which they are not, they are not applicable for two reasons. One, it's an existing driveway and RSIS does not apply to existing improved areas. The second is that it's not just a residential driveway. It serves mixed uses, commercial and residential, and RSIS states that under those terms where there are mixed uses and the residential is not discrete, RSIS regulations do not apply. However, if they did, this type of a driveway could be 20 feet in width. So we are providing an appropriate width for this driveway to serve this area. And it is an enhancement over what is there today because it's 5 feet wider. The grade, the Borough Code permits a maximum driveway grade within 25 feet of the right-of-way of 2%, where 5% is proposed and 10% is proposed for the remainder of the driveway. This is an existing condition. We have to maintain that existing grade, both for access to the shared parking on lots 22 and 23, and also to meet the existing grade at the rear of the building, at the northeast corner of the building here, adjacent to lot 11, because we're not modifying the grade of lot 11. One thing I do want to point out at this point is that we have agreed, I don't recall which one of the many review letters we got, or we are going to repave the existing paved area at the rear of our property on lot 11 between the enclosure area in the northwest corner of our site out to the common driveway, the shared driveway that runs on lots 23 and 24. We are, as I mentioned before, we are requesting a design waiver for the width of the sidewalk along this driveway. We generally have 4 feet width, which is what's the minimum required. The only place we do not is at the existing step from the existing door on the west facade of the building on lot 23. Now, in our application, on the plans, we had identified also that we needed an RSIS de minimis exception in not providing sidewalks on both sides of the entrance drive. We are providing it on one side, but again, this driveway and the associated sidewalks in this area are not subject to RSIS because this is not a residential only driveway. So that was a mistake on our plans, which we will correct. But the RSIS exception for the width of this driveway and for not providing sidewalks on both sides will be removed because it is not the jurisdiction of the residential site improvement standards.
Eric, if I can just stop you there, there's no sidewalk there currently at all, correct?
There is not.
Thank you.
There is not. Okay. So, as I indicated, we are going to reconstruct and repave the parking area behind the buildings on lots 22 and 23. We'll restripe that lot. We are providing river rock edging in here. And the reason we're doing that is we do not propose to curb this parking lot, which is another design waiver that we're requesting. And the reason that we don't want to provide curbing is that today, as I said, this whole area is impervious coverage and it sheet flows off in a northeasterly direction. If we curb this easterly edge of the parking lot, we're going to direct all of the flow to the northeast corner, concentrate the flow, which is not a good engineering design. By providing this river rock edge, it will allow us to maintain the sheet flow that exists today, to allow the runoff from this parking lot to enter into what will now be an open space area, a grass area that will allow, one, the velocity of the runoff to be decreased, and also an opportunity to provide water quality within this parking lot, which does not exist today. At the request of the property owner, there is an access gate into this lot. Today, there is no control into this area. And it is, I'm sure you've all been out there. It is very open and there is very little definition. This plan will create a lot more definition, and the owners have asked that we provide an access gate so that they can control who can park in this area behind the building. And that gate, this area is for automobile parking. Deliveries are not taken back here. There are no garbage facilities back here. So that gate is suitable for the types of vehicles that will be entering that parking lot. I need to go back. One other design waiver that we are seeking is in the parking level underneath the building itself. And this is both a borough design waiver and an RSIS de minimis exception. And in this case, RSIS does apply because this parking area is solely for the use of the residential units within the building. There is no accommodation for retail parking or any other kind of parking. So this parking area is subject to RSIS. Both the borough code and RSIS state that parking spaces are to be 9 feet in width and 18 feet in length. We are providing 18-foot deep parking spaces. But as you can see in the plan, this is sheet 7 of our site plan set. This is in the lower left-hand corner of that sheet. You can see these little black squares are columns. The specific size of them has not been fully engineered at this point, but generally they would be 12 to 15 inches in dimension, which means that at the point where there is a column, the parking space would be between 8'3" and 8'6" in size. And that requires a design waiver from the Borough Code and an RSI as the minimis exception. However, functionally, this does not have any impact on the functionality of these parking spaces, the accessibility of these parking spaces, the ability of people to get in and out of their cars, because these are at the back of the vehicle, not where somebody would be opening the door. So we are requesting a waiver and a RSI as de minimis exception. And in no cases are those columns on both sides of a single space. As you can see here, the column or that restriction is only on one side of the parking space. I want to talk very briefly about landscaping.
Eric, before you do that, can I just, one detail on
Sure.
the improvements on lots 22 and 23? There was a request from the board professionals that we add a guide rail.
Yes.
You show us-
We're willing to add a guide rail along these 7 parking spaces. It would be set behind the River Rock strip so that a vehicle would not enter into this lawn area. So,
Thank you.
you're welcome. I get to it right. So, as far as landscaping, as I said, almost all of this lot is currently impervious and will continue to be impervious, though we are reducing it somewhat. We do have a small planter area that's available between the residential entry and where the notch is in the back of the building. And the area along this planting is 1 or 2 units, which Mr. Gertler will talk about. Because it has a shallow soil depth, because the mechanical and electrical room are located beneath this at the garage level, we are providing an ornamental grass in this area. If this is not a native variety, we will change it to a native plant. Mr. Gertler will also talk about the planters on the roof level, and we will select an appropriate native plant or native tree for the planters on the roof terrace. But I'll let Mr. Gertler talk about that a little bit later. We will also, and it's not shown on the plans today, but it will be added, as I indicated, the newly created pervious area, lawn area between the new parking lot on lots 22 and 23 and the lot 12 property line will be landscaped and will include a shade tree in accordance with the Borough Code. All of the landscaping on this project will be guaranteed for 2 years, which is a standard practice. We do have 2 retaining walls. Actually, it's really 1 retaining wall. It just has two components I'm sorry, there are 2 retaining walls. We have a retaining wall between the post office driveway to the west of us, because the ground today slopes from Lincoln Place towards the rear, and we are providing a walkway area that needs to be level to get into the building. We have a wall along the west side of the property extending to the rear of the building. And then we also have a retaining wall in the northwest corner where we are providing dumpsters, and if need be, depending on the requirements of the Madison Electric Company, a potential transformer, exterior transformer in this area within this enclosure. The Borough Code requires that retaining walls be set back from the property line to the height of that retaining wall. We have a maximum height wall by the post office of 5.2 feet. But that wall is not set back. It is on the property line. So we need a design waiver to not provide a setback for that retaining wall. And accordingly, we also have the wall at the northwest corner is a maximum of 2.3 feet in height. And again, that is set on the property line. And that requires a design waiver as well. And that's just to make up the grade between the existing topography on the post office side, and also for this rear one, the lands on lot 8 with the grading within this portion of the building area. Okay. Lighting. We are providing building mounted lights on this building along the residential walkway, along the street frontage, and along the driveway and at the rear of the building. Just sorry to move around. Building light types A and B are rectangular building mounted fixtures that are full cutoff and direct light in a downward direction. Those lights A and B are located along the west, the south, and the east sides of the building. In all cases, these lights are, in the case of the west and south side, are under the canopies that are on those 2 sides of the building. On the east side of the building, and Mr. Gertler will talk about this when he testifies, the first floor and the garage level are set back somewhat from the second and third floors. The second and third floors cantilever out, and these lights are located underneath that cantilever. So again, even though they are full cutoff, they have absolutely no exposure to the sky and to the lands to the air above. So there is no sky glow. There is no glare created from those. Light type C, which there are 4 located along the front of the building, are, let me zoom in, are wall sconces. They are decorative light fixtures to provide aesthetic. I struggle with this. I'm an engineer. Aesthetics are not my area of expertise. I leave that to the architects, but they are part of the building design. We worked with Mr. Gertler's office to select a fixture that is appropriate for the building, fits in with the building design. And I apologize, I am struggling to find the one that we selected. Oh, okay. And I'm not even going to try and pronounce it. Oumuamua. This fixture here, it has frosted glass, it has a diffuser, and what we're, so it has very little, or it has diffuse light that comes out in the horizontal plane. We are also proposing to have clear lenses on the top and bottom to provide some limited amount of uplighting and downlighting. I hope I'm not making anybody dizzy by moving around my screen. The two end C fixtures are underneath canopies. So the uplighting is just a wash on the portion of the building underneath the canopies. The two middle ones, which are on either side of the retail entryways, are between the canopies. So there would be a little bit more uplighting along the facade of the building in those areas. But these are low wattage fixtures. It just provides some architectural and visual interest to the building. So those would have some uplighting above the canopy. Sorry, I lost my spot for a minute. The lighting along the residential walkway on the west side of the building, the driveway on the east side of the building, and at the rear of the building would be on from dusk to dawn for security purposes. The lighting along the front facade of the building, both the B and C fixtures, would be on from dusk till 11 p.m. when they would be shut off. We do not propose any lighting improvements within the reconfigured parking lot on lots 22 and 23. And we request a design waiver from the Borough Code to modify the existing lighting that exists in that area today. As I indicated previously, there are exterior recycling and refuse containers that will be in an enclosed area at the northwest corner of the site. They will be, and Mr. Gertler will describe the interior trash and recycling collection and how it comes out here. Today, garbage trucks serve this area, serve the building on lot 11. And the trucks will come down to serve this building, and those units will be brought out to the truck. They will be picked up, and then the truck will leave. And in a similar manner as what occurs today. And I know there's a discrepancy between our plans and Mr. Gertler's plans. The intent is that there is a chain link gate on this enclosure. That chain link will have brown vinyl slats for screening, and the chain link fence will be no more than 6 feet in height. We are also requesting a design waiver for the setback of the refuse storage area. As you can all see, this site is very tight, it's very constrained. The Borough Code requires a setback of 25 feet for a refuse storage area. And this area is set back 1.1 feet from the property line. So that's again, a design waiver for the setback, but it is fully shielded. It's adjacent to a garage on lot 8. The south end of the building on lot 11, I believe, if I recall correctly, is a solid wall. So there is no, this is a service area today and will essentially continue to serve as one.
Eric, the testimony you've just given on trash and recycling, you're showing us which sheet at this point?
Oh, I'm sorry. This is again, sheet 4, the layout, grading, and utility plan. I apologize.
No worries.
The last thing on my direct testimony that I would like to discuss is stormwater. Stormwater is always a topic of interest to the public and to the board. As I indicated, this site is almost all building or impervious coverage today. We are reducing it slightly, and that's predominantly by creating the planter area on the west side of the building and some areas at the base of the building on the driveway side. Putting that aside, this project does not meet the thresholds under the state or local stormwater regulations as a major project, major development. And that's because we are not creating a 1/4 acre of new impervious, and we're not disturbing 1 acre. So the state stormwater regulations do not apply to the redevelopment of this site. Accordingly, we are not required to meet quantity reductions, provide water quality, or to provide groundwater recharge. The Borough Code also has a requirement that if you increase the roof area by more than 400 square feet, you are obligated to provide for recharge. Our roof area is only increasing by 362 square feet, so we do not meet that threshold, and therefore we are not required to provide groundwater recharge. We are, however, providing 2 seepage pits at the northwest corner of the building, and those are for storage purposes. Currently, the existing building is a peaked roof. The western portion of that building discharges to roof drains, which drop onto the ground and go onto the post office property. The eastern portion of the building does the same thing. It has roof leaders that discharge into the driveway, the shared driveway. With this proposed design, because we are building to the property line along the post office, we can no longer discharge onto the post office property as we have in the past. So we are directing the roof drains internally within the building into these 2 seepage pits, which will then, as they fill and overflow, they will create sheet flow, which will go on to lot 11. But these attenuate the rate of runoff so that we are not increasing the rate of runoff onto the adjoining property, which is another aspect of stormwater regulations, and meet the requirements to not increase the rate of flow onto an area where the water currently doesn't go. Eventually, all of this water ends up out on Main Street. But there is an existing inlet, which does not show on this sheet on sheet 4, but it's just in the drive aisle on lot 11, where all of the water today sheet flows to that location and will continue to do so in the future. Mr. Gertler will talk a little bit more about this, but as I indicated, the rooftop amenity area will be served by roof drains, which will connect internally within the building, and will either, depending on what part of the roof they are located on, will either discharge into the driveway as what happens today, or they will be directed into the 2 seepage pits. There are, and these don't show on my plans, there are certain units that have private terraces. They would also have small area drains, which would again tie into the roof drain system and would be connected with the overall drainage system of the building. The garage itself, from the driveway to the garage entrance slopes up. Any snow, rain that comes off of vehicles that park in here, there will be a floor drain system, and I'll let Mr. Gertler talk more about it, but that floor drain system would connect to the seepage pits at the northwest corner of the property. So that's it on stormwater.
Okay, thank you, Eric. Eric, before we turn it over to the board for questions, there were some items in various review letters that I'd like to just hit on that we might not have addressed in your direct. The first set of comments comes from the planner review letter last revised January 24, 2021. I'd like to start with comment 1.16. As was discussed earlier, we're seeking a waiver from the environmental impact assessment. Can you explain why we think that's appropriate?
Yes. This is a fully developed site today. It has been developed for a lot of years. The impacts associated with the development of this proposed redevelopment do not affect any natural areas or any other impacts beyond the footprint of the building. Really, there's not a lot. There's nothing to cover in an EIS, in my opinion, and that was all confirmed in the preliminary environmental checklist that we submitted with the application. It's an existing developed site, and it will continue to be a developed site, though with a different building and a different use.
Thank you. Why don't we go to comment 1.17, just confirm that all the utilities will be underground?
Yes.
Okay. Comment 4.6. This is, I think you testified to in terms of how the refuse and recycling is going to work. There was a comment in 4.6 about an existing condition with the property owner of adjacent lot 11, apparently having some garbage cans there. We have been in contact with the owner of lot 11. They understand that those must be moved and they will be moved.
Correct.
Okay.
Correct.
Comment 4.
Question for you. I'm just a little curious. Where are they going to move them? Because opposite where they are right now, that's a fire zone.
I don't know. That's the property owner's responsibility, and as well as to comply with any other requirements.
Right, Peter, but if you're making this change, I think you have to tell us what's going to happen. Don't think you can just say, we don't know, it's their job. I think as part of this application, I think the board would like to know how that will work.
I noted that, and we'll have a conversation with that owner and come back to you. Thank you.
Fine.
Okay, 4.7 also relates to lot 11 and the property owner parking vans within the easement area. And pursuant to agreements between the applicant and that property owner, as long as the vans don't obstruct the garbage pickup process and the wheeling out of the containers to the end of the driveway, as Eric testified to, they are permitted to keep the vans there.
Great. I was out there last week. The van was parked there and there was plenty of room to maneuver the refuse and recycling containers around that parked van to get to the garbage truck. So.
Thank you, Eric. And finally, comment 4.8 talks about whether there will be a trash enclosure within the parking area on lots 22 and 23. Eric, in addition to having consulted the owner over there who indicated they did not wish to do that, what would creating a trash enclosure in that area where there is not one now, what would that do in terms of the parking impact?
You would lose, 1 to 2 parking spaces in this area to accommodate that. And I noted when I was out there that there were no trash receptacles currently in that area.
So there aren't permanent dumpsters there?
No.
Okay.
Do you know where they keep their solid waste? I mean, you got to put it somewhere. Is it in the building?
It may be. I mean, I did not go inside. I will note that there were 2 garbage cans located right next to these stairs. Since we're not, I'm sorry, I'm on sheet 4 of 9. This is in the northwest corner of the building on lot 23. There were 2 typical residential style trash cans in that area, and they would be able to remain in that area if that's what the owner so chose to do. Other than that, there were no visible trash cans in this area at the back of the building.
Okay, thank you, Eric. Let's switch over to the Hamel Associates, Inc. Letter dated January 26, 2021. Comment 6 there asks, how is snow removal to be performed? And I know that we had a conversation with the applicant and they indicated that they would be have a contractor through their active management of the site who would come in and remove the snow from the access way.
Correct. That's my understanding. And, depending on the amount of snow, they would either plow it to an area out of the way or they would remove it from the area.
Next is Mr. Harrington's memorandum to the board that has a date of January 26th. And I go to comment 14. And there it was discussed about a grease interceptor, which would typically be on site in the event you had a restaurant, right, Eric?
That is correct.
So the request from the applicant is, we have not identified a tenant for that commercial space. And we'd like to defer consideration of that until, and only if there is a restaurant. And Mr. Harrington, in his comment says, I quote, have no objection to this request. So that's our proposal on that.
Correct.
And then finally, the Environmental Commission review dated January 11, 2021, which deals with stormwater. Comment 7, do you want to address comment 7? Let's see what that is.
Yeah, I think I did with, why we've provided the seepage pits, why they're located here. And if anybody's read the stormwater report, there are 2 design points. Design point 1 is the inlet on lot 11. Design point 2 is a point on the post office property. Because we're taking the western roof and moving it from design point 2 to design point 1, we have to attenuate the runoff from that area. And that's why these seepage pits are located where they are, is to attenuate that runoff.
Okay. And then finally, there's a comment regarding runoff during construction conditions. How will that be dealt with?
That's a purview of the Soil Conservation District and will be covered under our soil erosion certification.
And there will be, I'm sure, if not multiple, certainly pre-construction meetings with borough officials. That's routine, correct?
Standard practice, yes.
Right, so those types of issues and others will all be addressed.
Yes, sir.
Okay. Eric, do you have any other testimony you'd like to provide before we turn you over for questions?
Nope, that's everything I had.
Okay, thank you, Eric. Mr. Chairman, that concludes his direct testimony and he's available for questions.
All right, well, what I would like to do is have each one of our experts refer back to their memos and not only ask general questions, but I would like them to more or less tick off any remaining items and satisfy themselves. And, you know, the board will jump in as that goes along, as well as maybe have some additional questions. So I thought maybe we start with Mr. Harrington, go through your memo, then we might hop into Mr. Stern, see what you have in terms of engineering points, and then certainly Mr. Maltz, we want to hear from you. Does that
Thank
sound
you.
good?
Thank you. Yep. Thank you, Mr. Chairman. Mr. Keller, referring to my memorandum, number 4 was questioning the location for the gas and electric meters. And you show them, well, actually, Mr. Gertler shows them in his plan, I believe, in the basement in 2 utility rooms. Has that been confirmed by the utility company as being an acceptable location? I know the Madison Water Company is now going to remote read, but I just want to make sure that those locations have been approved based on some other applications we've had when meters end up being on the external facade of buildings when it wasn't anticipated. We want to certainly avoid that at all costs.
Not to deflect, but I'm going to defer that to Mr. Gertler because it's really, you know, it's a building related issue. So
Understood.
don't forget about it. Ask Jeff about it.
Okay, will do. And again, that was repeated in item 10 of my memorandum, so I won't
Okay.
reiterate that. Item 12 was regard to hydrants and the provision of fire protection. You had indicated there were 2 hydrants local to the site, and the one we had talked about previously, well, we haven't talked about it yet, is to the rear of the site, and frequently there are vehicles parked there, which is an enforcement issue. But besides that issue, has the fire department confirmed that they are satisfied with the protection of this building with the 2 fire hydrants that are proximate to the site, as well as confirming the flows that are available for firefighting?
Yes, Mr. Harrington, one of my staff and Jeff's office and the applicant met with the fire department. He was satisfied with the locations of the hydrant, one off the northeast corner of the building, one out on Lincoln Place. I presume that I was not at the meeting, but our understanding from that meeting was that he was satisfied. Mr. Gertler will talk about is fully sprinklered. He will talk about that system, and my understanding is that that was satisfactory to the fire department.
Thank you, Mr. Keller.
You're welcome.
Can I hop in on that just for a second?
Sure.
Sure. Behind the new building, that rear wall where there's trash piled up there currently, wouldn't that be a fire zone when the new building is constructed? Have you specifically asked questions as to whether or not that would be deemed a fire zone?
Good question, Mr. Chairman. When we met with the fire department, he had asked for fire zones along both sides of the driveway. He did not ask for one at the rear of the building, as there is an existing fire zone adjacent to the residential building on lot 11. He did not request that there would be a fire, my understanding that there would be a fire zone against the rear wall of the building. There is none now. This building is actually set back a little over a foot from the property line where the existing building is on the property line, but he did not ask for a fire zone there.
Yeah, I think we should be a little more proactive than that. I would like you to document this conversation with the fire department, namely, I think we should have a memo from them setting forth what you assert in terms of what they're comfortable with. And also, I think you was said earlier that, because I know I did visit the site. I visited the site personally several times, at least 3 times, and walked the site up and down, all around, drove through it. And every time I went there, there was a delivery truck, I think from the British Emporium, parked next to, at the rear. And I have concern that if there's a delivery truck there, pretty much a lot, that would interfere with fire. And I don't understand why that truck could be there. That's not a designated parking spot. So I'm really not comfortable with that at this point. So I think you need to review or get the fire department to comment on these things that they're comfortable with that. I'd be surprised. So, but I'm not really comfortable. I do have some safety concerns. The firemen come there, there's a dumpster fire, and there's a truck parked in front of the gates. So that I think is a concern. And then also building number 12, lot 12, where it was pointed out that there's a hydrant that's actually, I think it's on the other lot. It's on a lot 11, I think.
Yes, sir.
Right?
Yeah.
And I know that Mr. Stern, you could probably chime in here too, because I think when he visited, he mentioned it to me, and I did see it, that there was always 2 or 3 cars parked in the fire zone up against that hydrant. And I'm just concerned. I'm just concerned that that fire zone, that area that's marked with the stripes, is necessary for turning moves, and I'm sure nobody's contemplating that there may be 1 to 3 vehicles parked there. So I think you need to comment on that.
Mr. Chairman, we hear your concerns, and we will circle back to the fire official that we met with, and we'll work on that.
Yeah, well, I'm just a little bit concerned that there's too many cars for this apartment building, and that's where they end up.
Understood. We'll address that.
Yeah, one addition to that, and Mr. Keller said, well, nothing's changed. They don't have one now, but you're creating a building with 24 dwelling units, which aren't there now. And I don't know if the residential, that may change the attitude of whether you need fire zones or not. You have people living there, that may be an issue. But that should be explored. I agree with the chairman.
Well, yeah, I mean, you have a fire zone at that apartment building, but then you got a delivery truck parked right in front of the fire zone. So
Right, yeah, great.
We hear you, Mr. Chairman. We'll address it.
Just as another issue related to the fire official. Can you hear me?
Yes.
Yes, just another issue related to that is the setbacks of those the dumpsters from the building. That should also be verified by the fire official.
In addition to that, Mr. Stern, there's a proposed electrical transformer in that enclosure as well.
Right.
Another reason to keep that area free of vehicles and accessible.
So I think what I saw, that was British Emporium truck, and I think that's owned by the same owner as lot 11, 12 as well. So I think it's all under common control, right?
Yes, sir.
Okay, I think we need a solution there.
We'll work on.
I'm sorry, one more quick comment while we're on that area. Mr. Keller said you're going to repave back there. What's the limit? Is that the 17-foot wide easement, or is it wider?
I don't know that we have defined it exactly. We will define it and we will
Okay.
show it on our plans.
I mean, it's an unusual shape. I mean, 17 feet, I don't know. And then you got a little extra room on the other side. Okay, think you should clarify that.
And the scope of improvement should also include, besides the repaving, it should include the fire zone striping as Leslie.
Yeah, whatever they're gonna
directed
do.
by the fire official.
Oh, no, absolutely. Any striping we remove we'll have to put back.
Shall I continue, Mr. Chairman? I'm gonna hope that's a yes.
I suggest you continue, Dennis.
Okay. Mr. Keller, some of these might delve into some architectural questions at this point, or at least for this couple of questions, but I know we've looked at this driveway circulation and you're proposing an 18-foot wide garage opening. I'm not really comfortable with a garage opening that narrow. And I do note that there is a man door to the, call it to the left or the south of the garage door.
Yes.
Just putting it out to see if there's any way at all to widen the garage door opening greater than what it's proposed at 18 feet. You had mentioned that if somebody was coming down the driveway, they would notice that the garage door was opening, which would indicate a vehicle was exiting the garage. I can imagine if it were to happen coincidentally, somebody might think that they hit their the garage door opener and they caused the door to open, and then you would have a potential conflict. So just, again, I know it's perhaps more of an architectural question, but I do have concerns with the narrow width of the garage door opening at only 18 feet.
I understood, Mr. Harrington. As I said, the likelihood of the two vehicles entering and exiting at the same time is very small because it is a small garage. I'm going to defer the ability of changing the garage opening to Mr. Gertler. But I mean, 18 feet, is 2 parking spaces. So it clearly can accommodate 2 vehicles moving in and out. And there is sufficient turning radius there for vehicles to make those maneuvers. So,
well, we could debate that, but again, I would like to investigate that potential to widen that driveway. Another question I have on the driveway entrance and the garage itself, which again may delve as much into architecture, is the height of the garage door opening and its ability to accept or to accommodate, oversized vehicles, particularly because there's a handicap accessible space that has to be van accessible, that the garage door and the garage structure itself has sufficient height to accept and to accommodate a handicapped accessible van.
I'm going to defer to Mr. Gertler. I think I know the answer, but I don't want to guess, so deferring.
Okay, understood. Thank you. With regard to stormwater management and the stormwater management plan, it does not, if I'm correct, it does not include lots 22 and 23. The plan itself is only with regard to the subject lot where the former theater was.
That's correct.
I would request that the board require a revised stormwater management plan that incorporates all of the areas of disturbance. And what I'd like also, Mr. Keller, is to confirm that including those additional areas, that this site plan application still does not qualify as a major under the DEP regulations of quarter new impervious or 1 acre of disturbance.
No, even the limited disturbance, and I think it's sheet 5 of our site plan set you look down here in the lower portion of the plan, the total area disturbance is 0.47 acres. So it's still well under an acre. And as I testified to, we have a significant reduction in impervious coverage on lots 22 and 23, where we're taking out the gravel and asphalt that already exists.
I would just like that confirmed in writing in the revised stormwater management plan.
So, Mr. Harrington, with what was described by the applicant in terms of the treatment of that land there where they'll remove the impervious and plant grass, do you think that that is sufficient? Because I guess what happens, you'll have surface runoff will cross over that stone there and go into the grasses. Will that satisfy you?
Mr. Chairman, that is exactly where I was going next. Thank you for that lead in. The river rock edge that you're proposing, Mr. Keller, really don't have any detail on that, but my suggestion is that's an opportunity for some enhanced stormwater treatment, perhaps to turn that into I would call it a water quality swale, or perhaps a percolation trench where it could be perhaps widened to several feet and constructed with an engineered sand mix to promote infiltration. Understanding that if we did have a significant flow, it could overflow into the landscaped area. But I think it's a nice opportunity to incorporate some green treatment to the paved area, which of course now is all broken up. So you're really not getting the same type of runoff as you will after it's freshly paved. And in that same vein, looking at the area of those two lots that is to be paved, it seems that it's excessive for the amount of parking that it's providing. I believe the width between the parking spaces, which is effectively the aisle width, is 37 feet when only 24 feet is required. So one suggestion or thought I had was the spots that are to the south, I guess there are 5 or 6 spots,
These here.
correct, in that area. If they could be shifted to the right on your plan, and perhaps another bioswale, another green area, landscaped area could be produced between those shifted spaces in the back of the building. I confess I'm not as familiar with it. I'm sure it's probably all paved now, but it might be an opportunity to reduce the impervious cover and add some landscape area to this existing parking.
Well, I think that's interesting because the Board of Adjustment is very concerned about impervious coverage, and we do our best to educate ourselves or to learn more about better ways to manage stormwater. So bioswales and other types of natural means is something that may be great here. So in other words, yeah, you got a lot of parking there for not a lot of space for not a lot of parking. And so maybe make that lot a little smaller and increase the area of non-impervious there and try and do something more modern in terms of stormwater management. Sorry, I don't have all the terms at my fingertips, but low maintenance landscaping, retention, planting of native vegetation, that type of thing. So can you come up with something with Mr. Harrington that?
Well, Mr. Chairman, if I might, a couple of points I want to make. One, we don't own this lot. We have to have a discussion with the property owner as to their willingness to accept those improvements. The other is that the 5 spaces that face the rear of the building, There are pedestrian access points here. Honestly, I haven't looked at this in detail, but there's stairways. There's a stairway up between the two buildings to link in place. There are sidewalks in there. So pulling that back, may not be feasible and create pedestrian access issues. It's also at the high point of the site. The lot slopes from the building in a northeasterly direction across the lot.
Well, why don't
you look at it rather than try to shoot it down tonight?
I mean, you got 7 or so spots on the right there. If you shifted those to the left and increased the.
Mr. Chairman, we will of course look at it.
Yeah, okay. I think that's a big goal. So.
Yep.
Important. And, if you can't do it all, so be it, but try and do it.
If I could just jump in for a moment, this is Russell. On my site inspections, I'm always seeing tandem parking going on where one vehicle's parked, behind the other vehicles. So that has to be also discussed with the property owner of lots 22 and 23, because if that parking is absolutely necessary, the loss would be significant to that property owner.
Just on that point, Mr. Stern, I mean, we have provided this plan to the property owner. They have accepted the plan, which is why it's part of our site plan set. So in my mind, that intimates that they are agreeable to the number of parking spaces we're providing.
But I don't want to preclude your further discussion with them to see if there is that possibility to introduce other stormwater management techniques to this tract.
Yeah, I think if you go on Google Earth, you'll see tandem parking
Yeah.
occurring there, because I looked today. So maybe they need. I was going to ask who parks there and why, and is the gate going to create issues? Is the public park there? Is it just had some questions. I mean,
the gate is at the request of the property owner.
right, but the board wants to make things better, not worse. And that's, I appreciate if this is extra perhaps to your client, but from the board's point of view, they don't want to bless something that's going to make things worse. Hopefully they'll make things better. I mean, that's what I think what we're talking about.
Yeah, I mean, this is some serious variances here, and we're looking for some positive criteria.
Yeah.
And wherever we can get it. Now, if you work in good faith and it's impossible to make a change to that, then come back and tell us.
Yeah.
Understood. We will look at it and we will come back.
Yeah.
Okay.
Absolutely.
Thank you. Thank you very much.
Another concern I have on stormwater management is the downspouts from the building on the, I guess it is the northeast corner, Mr. Keller, is indicated to discharge to grade. Right. I would like every effort to be made to get anything into stormwater management that we could, and get any runoff that's going to be onto paved surfaces, which could freeze, cause problems, to get that into some kind of a system, whether it's, routing it over to the detention system that's proposed, maybe a small cistern or maybe a small seepage pit could be put, right outside the garage door there, and we could tie the roof drain into an additional seepage pit. But I really have concerns of water discharging onto the pavement, understanding that it may be doing that now, but this is an opportunity to improve things. But also in that vein, I'd like consideration to a trench drain perhaps at the bottom of the driveway, maybe before the garage door entrance, to prevent water, because it looks like the water, based on the grading, is pitched toward the new building at that point. So I'd like to see if there be any cooperation maybe in installing a trench drain at the bottom of the driveway while it's still on the applicant's property, and tie that into the new detention system or a new seepage pit that I'm requesting or suggesting.
We'll take a look at all of that and see what we can do. And, you know, what we have to look at is where we can discharge it to.
Mhm.
But we'll certainly look into that.
And of course, all of these seepage pits are subject to percolation tests and, you know, soil's ability to absorb the water that we're hoping is going to be recharged.
Absolutely.
A couple of other points, Mr. Chairman, if I might.
Sure.
On the trash enclosure, I don't know if this has already been decided, but in looking at the detail for it, it seems to me that chain link fence with slats is subject to a lot of damage, and the slats get missing, and it's really kind of an old way of treating an enclosure. And in the borough code at 95-25-9, it says that the trash enclosure should be constructed with building materials. It should be, you know, in keeping with the architectural feel of the building. So I'm requesting or suggesting that perhaps that, except for the gate, that the two walls of the trash enclosure should be built with masonry materials similar to what's going to be used for the building.
Yeah, on that, what's the proposed aperture of the gate? Because if the trucks aren't going back there, you probably don't need that big a gate. You're just rolling the containers down the driveway. You follow that, Eric?
Yes, I do.
I didn't see detail. I mean, there's probably detail, but
There is, I don't want to, it's a double leaf gate, so it's probably 8 feet. But I'd have to check. But
Yeah.
again, you know, we'll consult with the architect and the owner on, you know, design options for this area.
that's good.
All right, and by the way, when you guys return, you'll just be able to, you'll have a list of all these things that we've asked you to note. You'll just be able to tick through them.
Taking good notes, sir.
Okay, good.
Last item, Mr. Chairman, since we're doing the improvements on the parking lots in lots 22 and 23, I don't know how applicable it is, but I think it might be in the borough's interest to have the applicant look at upgrading that parking lot with regard to lighting. In looking at it a couple of times, it seemed to be some floodlights on the back of buildings and maybe one typical street light, a Cobra head that was providing the lighting back there. I understand we're going to get some benefit from the building with the lighting, the building mounted lighting. And I understand, Mr. Keller, that this is, you know, would need to be discussed with the property owners. I think it might be a good opportunity to upgrade the whole rear of those properties at this time to comply with borough standards and to make for an overall, you know, safer, more attractive property.
Mr. Stern, did you want to comment on that at all?
Yeah, I'm in total agreement with that. Those parking lots look like years of, if not dozens of years of neglect. Unfortunately, pavement condition. There's gravel back out there. There's a Cobra head. There's a whole variety of wall lights, the spotlights. The lighting plan that was provided doesn't even cover the levels of illumination on those adjoining properties. So I think that's very important. I think they should look into that, being a part of this application, being the fact that the parking lot will be newly reconfigured, and we should address the safety of that at night with illumination.
How does the applicant feel about that?
It's on our list, Mr. Chairman.
Okay, good. So, Mr. Harrington, is that it for you right now?
Yes, it is, Mr. Chairman. Thank you.
Okay, before we move to Mr. Stern, I want to take a 5-minute break, give everybody at home a chance to get some more popcorn, and we'll come back to 5, all right?
All right.
All right, thanks.
Sounds good.
Okay, everybody, let's get going here.
Sounds good.
Waiting for the last people to come on board. Okay, we're gonna, well, I'm waiting for Mr. Gertler, wait till he hops on. Mr. Wilson, you want to get started or you want to wait? Oh, there he is. There he is, I think. Okay.
Yeah, Mr. Chairman, I understand that the board professionals have asked questions. I didn't know if there would be any other questions of Mr. Keller from
Yep.
either the board or the public.
Yeah, no, we have to move on to Mr. Stern. And I just wanted to ask, Mr. Stern, while I was off making a sandwich there for a second, and, you know, we talked about having the fire department, you know, write a memo, go look and, you know, give their opinion. Should the police also do that, given the magnitude of?
Yeah, absolutely. Sure.
Okay, so why don't we do that? I was thinking as I was off out of the room that there's matters of public safety there with what's going on with the parking and so forth. And it might be good for the police to, you know, maybe they haven't driven back there in 20 years. I don't know, but go in there, have a look and give their you know, opinion on this. Does that make sense?
Yes, absolutely. I think having them out there and taking a look at the parking situation and the circulation and then reviewing it in context to the proposed plan is a great idea. Something that should be done.
Yeah, and I'd suggest Dennis take the lead on that. I mean, he's a full-time employee of the borough and he might be the most appropriate one to reach out to both of them.
In addition to them, Mr. Chairman, I'd like the borough utilities, both the electric and water department, to review the plans as well and comment on the proposed location of the transformers and the meters.
Yeah, let's nail that down. Thank you. Okay, so Mr. Stern.
Okay. I don't know if the video's on here. I'm not seeing anything. I'm just gonna get rolling. The applicant had requested that waiver for the submission of the environmental impact statement, but in the review of the code, it's really only mandatory for subdivisions. Although later on in section 195-23C, there is language that says that basically if the board in their review of the site plan, you know, requires one, then they can. You know, I've seen many EISs over my career. The majority, unfortunately, tend to be somewhat light. So I think if there's specific concerns by the board, they should let the applicant know and have them address those environmental considerations. Eric, could you address the street furniture that's being proposed along Lincoln Place? I think some graphic renderings by the architect showed a bike rack, but that bike rack didn't seem to coincide with the DDC bike rack standards. So my recommendation is that those design details should be consistent with those that are currently being implemented for the downtown area.
Yeah, We've committed to providing a bike rack as well as a bench. There are already trash cans out there. We would do. One issue with the bike rack that we have to be careful about is that the sidewalk in front of this building and along this entire frontage is not as wide as possibly other sidewalks within the downtown. So we may seek a different style of bike rack so that we don't create a pedestrian impediment along the sidewalk. That's our only concern.
Yeah, I think you'll find that that DDC standard is one that doesn't consume a lot of space and may be workable for you. Can you tell us about,
we'll look into it.
Okay, could you tell us about the construction phasing as well as staging? Because construction along that common access drive is certainly going to encounter some problems. I know, of course, buildings like this are constructed all the time in New York City, but this is Madison. We also have to realize that the access off of Main Street by British Emporium, that is a one-way drive and only has a one-way drive width. So it's the direction of travel is from Main Street into the site. So could you go over the construction phasing and kind of like the timing of this? Should the board grant approval?
I think that might, I don't have all of the details on that. And I'm not.
May I suggest that we come up with a detail? We've had discussions already as it relates to discussions with the neighbors that are part of our application. We've also had discussions with the Postal Service and New Jersey Transit as it relates to their structures across and next to us. So we have that information. May I suggest that we come back with that? Perhaps we'll make a submission prior to our next appearance and then.
Certainly, that's fine.
Thank you.
Okay. I have a section on parking and circulation, but I will, for the time being, defer to the board's traffic consultant, Harold Maltz. In relationship to those 7 parking spaces on lot, I think it was 23, there is a waiver for the lack of granite block curb. You are proposing the gravel, I guess, river stone to accept the sheet runoff there, but the guide rail that goes there should be some type of aesthetic guide rail, maybe a timber guide rail.
Yes, we're agreeable to timber. That's
all right. In items 3.16, 3.17, I went into a bit of discussion about the parking lots on your adjoining lots, the problems with the vehicles from British Home Emporium, as well as resident vehicles. That place is heavily parked. You will look into that and at a subsequent meeting be able to address 3.16 and 3.17. The trash situation, I really don't understand fully at this point. I think we'll need Mr. Gertler to further explain how it all gets out into those dumpsters. And then when the garbage trucks come in, where do they park? Where do they stop? Because I think some testimony said that they will be wheeled out. And these guys really don't like wheeling out and moving around a lot of stuff. So we just need a little more clarification on that aspect of it. And when I've been out there, the favorite place of Pine Emporium, as well as pickup trucks to park, is right in that access way to the trash enclosure. So that should be addressed. Continuing. The site lighting, 5.1, 5.2 are issues that should be addressed next time we meet. Signage, I assume, will be addressed by Mr. Gertler. And that covers my questions as it relates to Mr. Keller.
Okay, let's move to the traffic aspect, and then Russell, you can come back to that with some of your stuff as well.
Okay, this is Harold Wald from the board's traffic consultant.
You're gonna need to crank up your volume. Can hardly hear you.
Oh, is that right?
Okay, better.
Better.
Okay, you can hear me now?
Yeah, and I'm sorry, that reminds me, I should swear in the borough consultants who've been talking. I forgot to do that. Mr. Maltz, we'll do you first. Do you solemnly swear the testimony you're about to give will be the truth?
Yes, I do.
And while I'm at it, Mr. Stern, if you could come back on.
Yes.
Do you solemnly swear the testimony you have given and will give will be the truth?
Yes, I do.
Okay, and who did I miss? Oh, Mr. Harrington. Are you still around?
Yep.
I
I
can't
am,
see you.
I am.
Because you're on another
Yes, I
screen.
am,
There
Mr.
you
Hall.
are. Do you solemnly swear the testimony you have given and will give in this matter will be the truth?
Yes, I do.
Thank you. Okay, we move on. Sorry about that.
Okay, this is Mr. Walsh. Can everybody hear me?
Yes.
Okay. I'm referring to my January 26, 2021.
You're fading away.
And basically the first part, which is the review of the site plans, I repeated my comments from my previous November 4th, 2020 review letter and put in bold my current comments, which reflected the responses by Mr. Keller. I'm just going to step through it. Comments number A, 1 and 2 needed no response. Comment number 3 related to the site distance at the drive exit at Lincoln Place. I had a lengthy discussion about how vehicles exit. Mr. Keller pretty much reiterated and agreed with me, but I did note in my comments so that everybody understands what we're talking about, that the applicant should present the response and testimony. So I'd like Mr. Keller to explain what's happening here with site distance as you exit the site, because it's a multiple sequential event.
Thank you, Mr. Maltz. The site distance for this property is really a two-stage process. One is the visibility of the pedestrians crossing this driveway, and I think that's enhanced by the widening of the driveway so that there's additional separation between the two buildings. And then the second is the vehicular site distance. AASHTO standards, American Association of State Highway and Transportation Officials, indicates that sight lines are to be measured 14.5 feet back from the edge of the travel lane. In that particular situation, or in this particular situation, where we have on-street parking, that point of measurement is not at the property line. It is actually partway into the apron. And what that does is that gets you in front of the buildings on either side and allows visibility in both directions for a more than sufficient distance to observe vehicles approaching either from Waverly Place or from Prospect Street. So that provides for both adequate sight distance for pedestrian crossings and then also for vehicles approaching along Lincoln Place.
Okay, if I could just add something.
You got to talk into your mic, Harold.
Can you hear me? Hello?
That's a little better.
Yeah, we can, Mr. Maltz, we can hear you when you face exactly the way you are right now and speak into your mic. But when you turn your head,
Okay.
you fade out.
Okay, don't know where the mic is on this.
No,
Just hope,
you're fading out again.
okay, I'm gonna stay very. What I like to say is.
Can't hear you.
I agree with,
I think you're too close, maybe.
I agree with what Mr. Keller said. I like to point out the location.
I-
First spot, somebody stopped by.
We can't hear you, Mr. Maltz.
You can't hear me again?
No.
So just give me a second. Let me see if I can get the volume up. Can you hear me any better?
We heard that.
Okay. Obviously, some stops at the stop line that allow so they can check for pedestrians. So when they move up in the position.
No, I can't hear
Can
you.
you hear me again?
No, you keep fading out.
I don't know what's going on.
Would there be a way for Mr. Maltz to, let's say, exit Zoom and call in on a telephone line? Would that be better? Mike Pellissier.
Yeah, he can call in. He can change to a phone number if he clicks down in the bottom left-hand corner where it says mute. If he clicks the little up arrow, he can say switch to phone audio and it'll get him the direct number to call in.
Okay.
Yeah, switch. That'd be better.
Okay, switch to phone audio. And
It'll give you a phone number and a password to put in.
okay, I see it. Hold on. What do I got to go to my telephone then, or what?
Yes.
Okay. Phone call. So dial. Okay, the first one is 301-715-8592, and it has meeting ID. Got to use that.
Yeah, and just don't read the password out loud, please.
Okay. Are you able to hear me?
Well, dial in because you were going in and out. I don't know. You need a new internet connection or a new laptop or something.
Well, this is a new laptop. I can hear everybody fine.
Okay. Well, we couldn't hear you.
Hold on. Okay, can everybody hear me now?
Wow, much better. Thank you.
Okay, it's working?
Yes.
Yes.
Okay.
Go ahead.
Yeah, so what I was talking about in relation to supplementing what Mr. Keller said, the first location is the stop bar, which vehicle stops there, and so you can see pedestrians. The second location he talked about was 14.5 feet back from the, I guess, the parking area that's in the street, which then sets it to the location approximately where he has it. Actually, when I measured on the plan, based on what he said, it's actually 3 feet further out into the street. Into the apron, closer to the street. But what I would note is, in reality, a driver is going to be moving up even further than that. The vehicle's position in reference to the front of the car could actually move almost all the way up to the street side edge of the parking space, which puts it about the front of the car 8 feet into the street, so the driver's eye really would fall right along the curb line. This would then extend the driver's view both to the east and the west, even further up and down the street. So you have a multi-step process here moving out. Then I would add one other thing. For a vehicle making a left turn out of the site drive,
looking to proceed east, you actually can have a two-step movement into the street. When he looks to the left, he sees a vehicle going westbound. He would wait for that to clear, and then you have a short median island. It's a vegetated median island, raised island, and driver could move up to that particular location and have an improved view from somebody coming down the east so that he can complete it. It's like a two-step operation. With these other locations, you have an expanded view to the east and west from the exiting driver as they logically move up the way they would truly operate. Mr. Keller, do you have any disagreement with what I've said?
I don't. Thank you.
Okay. Moving along in my report, that takes care of number 3. Number 4 relates to the truck and car turning templates. You already answered the issue about the garbage pickup. I did note in there didn't note that the garage door opening is 18 feet wide, and I said turning templates in and out of the garage access should be described. You did talk about it. Your turning template related to the 18-foot parking lot, 18-foot wide opening for the parking lot. You show a turning template for a passenger car going in, but you don't show one coming out. I'd like to see for the next meeting if you could produce that. I would also note, and I would tend to agree somewhat with Mr. Harrington, the reason I made note of the 18-foot wide opening is I think it is a little bit on the tight side. If it was possible to increase the width at all, it looks like there might be some room there. Speak to the architect and see if anything else can be done to widen it up a little bit, because it provides a little bit more maneuverability at that particular opening. So that's the only thing I have to say there. Let's see, 5. Number 5 needs no further response. The 6 is the snow removal and such. That's been responded to. Number 7 relates to the discussions on parking. I had a lengthy discussion on the RSIS. There's 47 spaces required based on the number of units in the bedroom count. By the way, I would note, I think in your report you had 46. It actually calculated out to 46.5 with the recent publication of it for the RSIS, an addendum. Anything 0.5 and up is now rounded up, whereas previously at 0.5 it rounded down. So the required RSIS spaces is 47. There are 24 spaces being proposed in the garage at 1 per unit. But the RSIS does note that alternative parking standards shall be accepted if the applicant demonstrates these standards better reflect local conditions. And factors affecting minimum number of parking spaces include household characteristics, availability of mass transit, urban versus suburban location, and available off-site parking resources. I did note, and I think you agreed with everything I said about the availability right across the street of the train station, and New Jersey Transit had a publication on which they noted that for a facility like we have here, the railroad station in Madison, it's known as a transit node, and parking requirement can be reduced by 25 to 30%. If you apply the 30% to the 47 required by RSIS, that comes down to 33 spaces. That's quite a bit lower, and this does not even take into account the central business district characteristics, any reductions there. I would note that, and I believe it was agreed to in the responses by both the attorney, applicant's attorney, and Mr. Keller, that the 24 apartment unit parking spaces would be have a condition of approval that there would only be 1 garage space provided for each tenant, and it would be identified as such in the lease agreement. And I believe that was agreed to by the applicant's representatives. If they don't, please say so now. Okay. Let me see. There's nothing on number 8. Number 9 relates to the any comments from fire officials. They show a turning template for a fire truck accessing the site drive. My question is, this is a narrow area. If the building was on fire, would a fire truck even be positioned so close to a burning building? It was requested that the applicant get written comments back from the fire officials. I think this is one of the things that they should respond to is, would they even go down that drive in order to fight a fire on an adjacent structure, actually positioning their equipment so close to the fire? I think that's one of the things they have to look into, and it should be asked.
This is Joe. I think that also you should know for the fire department that there's typically a truck parked back there, and I want to make sure that they know that when they're commenting.
Just
Yes,
on that
it's all
point,
very important.
just if I might on that point, we discussed that with the fire department. They would not, if this building were engulfed, they would not drive down that driveway. What they
Right,
asked,
it doesn't make sense.
right? What they asked is is access to the other lots in this area. Would they still be able to get a truck down there? And that's why we showed the truck turning path. Not for
Okay,
our
well,
building,
that's what I wanted to solicit from you, Eric.
right.
So we have that answer. The last comment or question I had, and I believe it's the applicant has agreed to do it, is there are 2 crosswalks located near the crossing Lincoln Place that are just off the frontage to the east and west of this particular site on Lincoln Place, and they go across the street. It's oriented to the train station. And currently there's no pedestrian crossing signs, assemblies, or advanced pedestrian crossing signs in either direction of Lincoln Place. But with the introduction of 24 units of 24 apartment units here, you're definitely going to encourage people to be using the train station. It's going to be a path back and forth. Consequently, I recommended that these sign assemblies be installed, and the applicant has indicated that they would do it, and it could be a condition of approval, which I would recommend. And I've requested that these signs be shown on the site plans and the sign details added to the construction detail plans. So after this, this relates to the comments A1 through 10 relate just to the site plans in my January 26th letter. Section C, which relates to the traffic study, hasn't been testified to, so I'm holding that in abeyance till Mr. Keller comes to his traffic testimony. But otherwise, all the other comments I had, I think have been addressed. The only thing I'm going to ask of to be supplemented is the turning template for passenger cars making a right turn out of the garage, to have that shown.
Agreed.
Okay, I think that's it for me for now.
Mr. Stern, did you have something you wanted to ask on that topic?
We're going to have to hear some testimony from the applicant regarding the variance for the parking quantity. I don't know if that's going to be Eric or another expert, but that'll have to be put on the record by the applicant.
I was planning on covering that later.
Okay.
Right, and then was there anything else, Mr. Stern, or is that it?
That's it for me right now.
Yeah, at some point, I don't have to, you don't have to do it now, but at some point I wanted to talk about the overall flow in and out of those lots out from Main Street to Lincoln Place and how that works and how it should work. But that's up to you whenever you want to introduce that topic.
I would suggest that it come during his traffic testimony, Mr. Chairman.
And that's Mr. Keller's going to do that?
He's going to come back after we do the architecture, yeah.
Oh, yes, they'll do it at that point. Okay, I understand. I better, okay, good. All right, I want to go to the board. Does the board have questions for this witness? I mean, we've covered a lot of ground. Is anything you want to talk about?
I had a little question about lighting. I know we talked briefly about lighting. Does the lighting comply with borough requirements for the amount of illumination off-site in all cases? I don't think it does. I'm not sure.
It does not, Mr. Skull. We are seeking a design waiver for lighting along the Lincoln Place sidewalk and along the driveway.
So it exceeds the borough's rules on what you're allowed to have.
That is correct.
Can I ask why? You're putting up brand new lights. What's the thought process there?
Well, the thought process, one is to provide, let me talk about the driveway first. The driveway, because the driveway is very close to the property line, what we're trying to do, and let me go to the, see if I, we're trying to illuminate the driveway in its entirety. So since the driveway is only partially on our property, but it's a common driveway, we wanted to illuminate the entire driveway. So that's why we're exceeding the light levels along the property line. The property line is this dashed line here. And we have 1 foot candle out into the far lane. And that's because we're trying to illuminate that whole driveway.
Okay.
Now along the frontage, what we're trying to do and trying to create, which we do in all downtown situations, is the building sits on the property line. So any light that we put on the front of the building is going to exceed the borough standards because it's, into the right of way. So what we think the lighting along here, in the main part of the sidewalk, the midpoint of the sidewalk, you're probably in a 4 to 4.5 foot candle level, which is a very comfortable, inviting area that enhances the streetscape. So that's why, again, any lighting that we put on the front of the building facing Lincoln Place would violate the standard because we have a 0 foot setback, which is permitted.
So is your philosophy there that since you're not disturbing any neighbors or residential uses there, that it's not a problem? Or is the problem that the borough standard doesn't accurately reflect what would be a more appropriate lighting level at the street? I'm trying to understand this because I think it's really important to have lighting that is comfortable for everyone and that does not over illuminate because late at night and at odd hours, it's hard for neighbors if lighting disturbs them.
Well, that's a very good point, Ms. Driscoll. 2 things. One, there are no residents that would be impacted. Across the street is the train station. The other is that these lights on the front of the building would turn off at 11 o'clock.
Okay.
So the lights on the residential access and on the driveway would be on at all times, but to the west is the post office and to the east is a commercial building. So we don't think that any of this lighting negatively impacts the neighbors and creates a desirable environment for the pedestrians.
Okay, how about in the back where you're near the small residential building that I think is on lot number 12?
There's a building over here. Lot 12 is down here. And then we also have the building on lot 11. As I indicated, we have 2 security lights at the back of this building. My recollection is the building on lot 11 has no windows on that side of the building, so we're not impacting that. And lot 8, this is a garage building.
Okay.
So this provides an appropriate level of illumination of this rear area, and provides appropriate security. So
Okay, thank you.
you're welcome.
Other board members?
Yeah, hey Joe, it's Tim. I just had a couple of clarifying questions around the gate between 24 and 23. I think I saw on the plans. Is this a chain link double leaf? Is that the gate style that we're talking about?
No, to lots 22 and 23, this is a mechanical gate to limit access into that parking lot.
Is there a detail of that gate? 'Cause that's what he's asking. What's it gonna look like?
I want to see the appearance of it. Yeah, all right.
I believe so, but I will check.
And when you do that, because the height may be an issue also, because I was going to ask on the fence to the left of that, you have 4-foot fence on top of a wall, and at the one end, it's almost 8 feet. Because under the Madison ordinance, I think you combine the wall and fence to get the height. At that front corner, it's just under a 4-foot high wall. It's not 4 feet, but it is. But the fence is 4
3
feet.
foot 8 inches. And we have a 4-foot decorative aluminum fence on top of that, which at this southern portion of this, is would be a total height of 7 foot 8 inches.
Yeah, I can't remember if you're allowed 6 or 8 on this property, but just make sure it's okay, because you do combine the two under the Madison ordinance.
Okay.
That would be an open fence, I guess, Gary?
It's a decorative aluminum fence. So yes, it's open.
Yes, okay.
Yeah. Just to go back to Mr. Fitzsimmons' first question, there is a detail of the gate on sheet 8 of our plans.
Oh, it's okay. It's that kind.
So yeah, it's this kind. It's just an arm.
It's an arm. Okay.
Yeah,
got it. Got it. Okay.
Are you operated by a fob or a card or something? Because
something like that. I'm not exactly
if it's
sure.
a card, people would be stopping in the traffic lane. That's, I would think. If you click something, you wouldn't have that issue. You follow that?
Yes. I'm just making a note of that to
I'm
find
not
it.
sure. I couldn't do the math how far the gate is from the curb line, but it's probably less than a car length, I would guess. But
it's approximately 6 or 7 feet from the curb line.
okay, yeah. So you don't want somebody putting a card in a box. They'll be stopped in the road, in the line in the driveway. Okay. And Tim, I interrupted. Are you done?
Yes, that answers my question.
Okay. I had a few while we're on that area of the property. Mr. Keller, the fence to the right of the gate in that driveway, what is that? Is that existing?
No, that's a continuation of the 4-foot high decorative.
Okay, it's just not on the retaining wall there.
Right.
Okay.
No, it's just to create a continuous visual along that edge.
Right. No, I just didn't see a note saying what it was. That's all. And that continues around to lot 12. That I couldn't follow what's happening over there. Is that a fence on the south line of lot 12?
Yeah. Yes.
Because I guess down the bottom it said end fence at existing fence. Okay.
Yes.
That's a new fence along lot 12 there?
Correct. That was requested by the owners of lots 22 and 23.
Okay, that's understood. Yeah, and on that lot 12, what is that residential? What is that?
What's that?
The building on lot 12,
Um,
two-story frame building.
I'm not 100% sure, Mr. Hall.
Because obviously it's landlocked. I'm just wondering, whoever goes there, where do they park? I mean, that's other than illegally in the fire zone. I mean, I don't know.
That building is either a 2 or 3 family. It gives that appearance.
Yeah, I mean, that raises the parking question. I mean, whatever's there is there, but I'm back to saying we don't want to make it worse. And along those lines, none of the plans, except I think the survey, show the, I guess, the eastern half of lot 11. I mean, what's there? I mean, you can see a couple parking spaces. I think if you look on the survey, it goes further. Oh, yeah, there. See, it ends in the middle. I'm just trying to, and that gets to where I guess it goes under the building at some point. You have the survey? Oh, is that the survey?
I'm not sure how far our survey went because we did not survey. I don't believe we surveyed lot 11. I'd have to double check.
Yeah.
There was angled parking along the right side of this driveway opposite the building on lot 11.
But I thought I heard that angle, so you think to get in there, you'd be driving toward Main Street, but I'm told that the driveway is supposed to be in only from Main Street, so do people go out there and you'd have, I don't understand how that works. I think the chairman was asking the same question, how?
Yeah, I would say when I was, as I said, I visited the site multiple times. I drove down the driveway. I parked my car, just sort of left it running because there was no place to park. So I kind of put it on the side there and then walked around. And what I did observe was cars coming down the driveway and then parking in the apartments there, I'll call them, on lot 11, and then exit out through the British Pine Emporium and out onto Main Street. And what struck me is there's arrows on the pavement there right at Main Street that shows, hey, this is enter. So in other words, I saw at least 2 cars drive the opposite way of what's marked and then pop out on the sidewalk on Main Street, which I was concerned about. And so it sort of struck me that maybe those parking lines, the stripes there that, in what we're looking at now, they slant to the left towards Lincoln, or might be the opposite way of really the way they're supposed to be. So you can answer all that, I think, with the traffic discussion, but I obviously could see what was going on. I was there, saw it on more than one occasion. So that was my concern, is what exactly is supposed to happen here?
Yeah, and I'm wondering, as we're talking about parking, I appreciate the commitment, one, to assign space for each 24 units, but are visitors going to necessarily park on the street, or will they drive in there and use one of those spaces? I mean, that's a question whether by adding 24 apartments, you're exacerbating the situation in the back there. I don't know how to deal with that. I throw that out for.
Well, visitor parking the parking on the adjacent lots, is, I don't recall if it's signed. It is for, for those residents, whether it's allowed for their visitors, I don't know. Visitors to this building would be parking, on the street or in municipal lots.
I'm saying maybe they won't park there. I know what you're saying. That's your plan, but I just throw it out. It looks like there's a lot going on here, and I think the board just wants to make sure you're not making it worse. That's all. I understand what's there is there, and it's pre-existing, but.
Gary, when you said, or was it Russell, about the building on lot 12, when I was there, I did see there was 2 mailboxes, 6A and 6B, so I assume it's at least 2 units in that.
Yeah, we don't know where they park legally. Okay. I think that's all I really had other than, oh, well, one other thing real quick on the garbage truck template that somebody asked about. I see there it has it stopping there. I mean, it looks like it would be stopping right in front of the gate for the parking under the building. I don't know.
Well, again,
If it's not going to turn, I think somebody said, well, people don't like, that's pretty good transit between where you're keeping the dumpster and where the truck would be. I don't know. I throw that out.
yeah, I mean, the point of showing this was that it could access the driveway and get into the site. You know, there's garbage pickup now for lot 11 and that comes down in there. So, you know, we're just showing that they can access this driveway. I mean, they access it today through a 15-foot wide driveway. It's not that they would stop there. They would stop at the bottom.
All right. But you're not claiming they could make that turn though. That's all.
Which term, Mr. Hall? I don't.
The turn so they back up to the storage area. That's all.
No. We're bringing the, and Mr. Gertler will talk more about this, but we're bringing the dumpsters out to the truck.
Okay, I understand that. I just want to confirm that. Okay.
But further clarification, you're bringing the dumpsters out to the truck 20 feet away, 40 feet away, or just outside of the gate?
We'll look into the specifics. I'm not exactly sure how that, you know, and I'm not sure we've gotten into that level of detail on operations. That would be dealing with the specific corridor. So we'll get you some more information on that.
Yeah, I guess a logical question would be, how does the truck leave? Does it reverse out the driveway, or does it somehow turn someplace?
I think it's backing in. I think something showed it backing in.
Oh, it backs down the driveway. Okay, well, whatever. You guys can talk about that when you're ready.
That's how I construed it,
I don't know.
but who knows? Okay.
Ready, those are questions you'll get, so you'll be prepared.
We actually have had specific discussions, Mr. Chairman, about garbage pickup and how the operations would work. Eric was not going to be the witness on that, so we'll provide the information at our next session.
Right. So, and just so you know, we're just trying to be fair with you. When we've worked on other applications like a bank or other retail things, we spend a lot of time on this because we want to make sure it's safe and it works and doesn't create a problem, right? So
we understand and we appreciate all your interest in on the application.
Okay, thank you. Now, were there other questions from the board? I want to make sure the board has asked everything it wants.
The new greenery we're trying to create there, who's maintaining that? You, I assume, but just wanted to make sure I knew.
Sorry, Mr. Petzel, who's maintaining what?
The new greenery that you're creating on lot 22 and 23, you're maintaining that?
That's the responsibility of the owners of each lot.
Okay, you're creating it for them and they're going to take care of it.
Yes.
One quick question on that. I had a note. Mr. Keller, you said that area would be landscaped per borough code. Which borough code provision were you referring to?
I'm sorry, Mr. Hall. Good clarification. It's for the shade tree. This was in Mr. Stern's review.
There are street tree requirements, but that wouldn't be it.
There's a requirement for, here it is. It's landscaping. This is 3.20 in Mr. Stern's review. This is in accordance with section 195-25.15 C and M. One of them deals with you need to have one shade tree for so many parking spaces, and then the other is 10% of the lot. And we That
No,
area,
it's 10% of the parking lot, so it's 0 in this case, but I mean, that's how it's interpreted. And correct me if I'm wrong, Mr. Stern, but
It looks like it's still a waiver, yeah.
I mean, the 10% is within the parking lot, not next to it. We had that with the Heller application. But I forgot, there is also the tree per space issue. Okay. I just didn't know what you're referring to, make sure.
that's what I was referring to.
Okay, but the 10% is a waiver
Okay,
because it says within the parking area, not next to it.
okay. Understood. It's,
Okay, that's fine.
So is there other board members with questions? Okay, so there being none, then it would be time to ask the public for any questions. So I guess that would be Mr. Simon would be given the opportunity first. Is that right, Mr. Hall?
Yeah, though at 11:15 and Mr. Keller, I assume, is going to come back with some more things. I wonder if that, but I guess we could start.
Yeah, I mean, it's up to the board, of course, Mr. Chairman. Certainly, a lot of questions that I had were the same questions that the board and its professionals had asked, to which the applicant appears to want to or going to come back to get some more information. So I can start and ask some questions, or I can wait until the plans are revised or the additional information given. And I think, Mr. Chairman, you raised an excellent point earlier in that some of the questions morph into site circulation. So I don't know if it's more prudent, and I'm always into being as efficient as possible, waiting until Mr. Keller provides some testimony, at least with regard to site circulation, before I get into questions, but that's up to the board.
Yeah, I'd suggest if you have some that I agree, that are freestanding, that I don't want that, or they may have to come back. We don't want to come back twice.
No, I understand that. I mean, it's hard.
I know it's a fine distinction.
Yeah, it is, and it's hard to kind of parse out. I mean, I can start asking some questions, but it's up to the board.
Okay.
Well, it's getting kind of late, board. Do you want to call it a night on this one? I want to have a mutiny.
You okay with calling it a night? It's getting late and we clearly are not finishing tonight.
Yeah. So, all right. So then what we're going to do is we'll adjourn for tonight, and then we'll have to work out when we'll have you return. I don't know whether we got a long way to go. I think you've done a great job so far, really getting a lot of information out, but there's just a lot of information. So I don't know if you prefer another special. That might be a good way to go, but we can work that out. You don't have to do it now.
Well, Mr. Chairman, we, first of all, we appreciate the board meeting an extra night tonight, and we hear that you have a special meeting on another project in February. We did coordinate amongst our team for possible dates that would work for a special next month. I don't know what the agenda is like for your regular meeting in February, but obviously from our perspective, we would love as much time as often as the board can indulge us. In terms of possible special meeting nights in February, the 18th and the 23rd work for our team. I think I heard that you already have one scheduled close to one of those dates.
25,
25th.
I think.
Yes.
I'd suggest we carry it to the regular meeting on February 11 and either give you some time or discuss further scheduling then. So it's noticed to a date certain. Doesn't mean, but we're not committing as to what time, if any, we can give you that night.
Don't we already have a night, Gary?
Yeah, we do. But that's what I'm saying. We, rather than, if you give it a date, then there's no notice issue.
Okay.
Okay, in the meantime,
Carry it, and then maybe further carried. It probably will be further carried, but at least that gives us a date. So
Okay.
the board's not going to hear it between now and then. That's 2 weeks away. Unfortunately, next month, we already have 2 meetings, so, but we'll see.
Right.
Maybe there's some time next in the February 11, but I think that that approach would, avoid them having to renotice.
So our attorneys can communicate and then they'll survey the board.
Right, and I don't know, I think the board has given them a lot of food for thought on some issues tonight, and, query how soon they can get back on that. But I think that for now, that's an interim approach that I would suggest.
So that the matter will be carried till February 11th at
The
7:30.
regular meeting's on the calendar, and we'll go from there.
With no further notice.
No
Okay.
further notice and no guarantee we're going to hear anything that night on this application. But
Right.
it'll be on the agenda, either to hear something or schedule the next step.
You guys can coordinate.
Yeah.
Maybe on the 11th, we'll schedule the next meeting.
Yeah.
Right? So.
That's fine. So
Mr. Santoro, you do have members of the public with their hands raised.
Well, the problem is we're late, so the way that would, okay, this is for the public. So after each witness, we go to the public to ask questions. But because we have an attorney representing some objectors, he's gonna go first, okay? And then, so at the next meeting or soon, he'll ask those questions. And then the public will get their opportunity as well. So everybody gets an opportunity to ask questions of the witnesses. And then if Mr. Simon at the end decides he's going to present an objector case, he could do that. And then there's going to be an opportunity for the public then to ask questions. And at the very end, there'll be an opportunity for the public to make a statement either in support or opposition to the application, maybe even offer testimony and be sworn in. But there's plenty of opportunity for the public to ask their questions. It's just late.
Mr. Chairman, can I just make a request?
Okay.
Just to the extent that the applicant is going to be submitting revised plans, documents, or reports in connection with this application, I respectfully ask that I be provided with a copy at the time that they're filed, and I certainly would pay for any copying costs or associated fees with that.
Mr. Wolfson, I assume you have no problem with that?
we have no problem with that. We want to
Okay.
avoid any.
I mean, it's more efficient if it goes direct from you rather than through us and then to Mr. Simon. So
That's why I was
we
suggesting.
appreciate that.
We'll do.
Thank
Yeah,
you, Peter.
And the board secretary is great and she's very responsive. So it seems like if it seems, Mr. Simon, that you're missing something, just contact Ms. Boardman. She'll get it right out to you.
Yeah, and if Mr. Wilson gives us something new, that'll be posted as well.
Yeah, Fran was incredibly responsive when I contacted her, and I thank her for that.
Yeah. All right.
All right. Well, is there anything else that we need to consider tonight? Because I'll move to adjourn.
I don't think so.
Okay, so get a motion to adjourn this meeting, please.
So moved.
Second.
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 Okay, all in favor of adjourning, please say aye.
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 Opposed? Okay, this meeting is adjourned.
Night, everybody.
Thank you, everybody.
Good night.
Aye.
Good night.